Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.209, Immigration Law. Conceptual Foundations of Immigration Law, Sovereignty, Rights, and Status. 1.1 State Sovereignty and the Power to Exclude. Immigration law is fundamentally rooted in the concept of state sovereignty. Under international law, states possess the inherent right to control their borders, determine who may enter, and establish conditions for residence. This power is not absolute but is subject to international human rights obligations, treaty commitments, and domestic constitutional constraints. The tension between sovereign control and individual rights defines much of immigration litigation and policy. Real-life example, in Chai Chon-ping v. United States, 1889, the U.S. Supreme Court established the plenary power doctrine, holding that Congress has broad, unreviewable authority over immigration as an aspect of national sovereignty. This case upheld the Chinese Exclusion Act, demonstrating how sovereignty arguments can override individual liberty interests. Conversely, in Zedvitas v. Davis, 2001, the court limited indefinite detention of removable aliens, showing that constitutional due process rights still apply within the sovereign framework. Practical application: lawyers advising clients on entry must understand that visa issuance is a privilege, not a right. However, once within the jurisdiction, certain constitutional protections attach. Practitioners must balance arguments based on statutory eligibility with constitutional claims when challenging deportation orders. Students analyze cases where sovereign power clashes with human rights norms, such as non-refoulement obligations under the Refugee Convention. 1.2 Classification of status: citizens, nationals, residents, and non-immigrants. Immigration law creates a hierarchy of status, each carrying distinct rights and obligations. Citizens possess full political rights, cannot be deported, and have unconditional right to enter. Nationals owe permanent allegiance but may lack full political rights, e.g., U.S. nationals in American Samoa. Lawful permanent residents, LPRs, have right to live and work indefinitely but can be deported for certain crimes or violations. Non-immigrants, temporary status for specific purposes, tourism, study, work, with strict compliance requirements. Undocumented persons, present without authorization, limited rights but entitled to basic due process and emergency care. Real-life example, in Plyler v. Doe, 1982, the Supreme Court held that states cannot deny public education to undocumented children, recognizing that even undocumented persons possess certain constitutional protections. This illustrates the nuanced rights attached to different status classifications. Practical application: lawyers must accurately classify clients to determine eligibility for benefits, protection from removal, and pathways to citizenship. Misclassification can lead to deportation. Students practice analyzing fact patterns to determine status and associated rights. 1.3 Theoretical frameworks: assimilation, multiculturalism, and global mobility. Immigration policy reflects broader societal theories about integration. Assimilation, expectation that immigrants adopt host culture norms, melting pot. Multiculturalism, recognition and preservation of distinct cultural identities, salad bowl. Global mobility, economic focus on labor flow and talent competition, human capital. Real-life example, Canada's points-based immigration system emphasizes global mobility and economic contribution, selecting immigrants based on skills and education. In contrast, historical U.S. policies often emphasized assimilation through English language requirements and civic tests. These frameworks shape visa categories and integration programs. Practical application: lawyers advising on policy or advocacy must understand the underlying theoretical goals of the regime they operate within. Arguments for family reunification appeal to multicultural values, arguments for skilled visas appeal to economic mobility. Students analyze policy documents to identify underlying theoretical commitments. 2. Statutory and regulatory frameworks: visas, admissibility, and removal. 2.1 Visa categories and eligibility requirements. Visas are the primary mechanism for legal entry. Immigrant visas, for permanent residence, family-sponsored, employment-based, diversity lottery. Non-immigrant visas, for temporary stay, B1/B2 visitors, F1 students, H1B workers, L1 intercompany transferees. Requirements: petition approval, consular processing, medical exams, security checks. Real-life example: the H1B visa cap creates annual competition for skilled workers. In ITSO v. Napolitano, 2011, challenges to visa bulletin interpretations highlighted the complexity of statutory quotas. Employers must plan years in advance for sponsorship. Practical application: lawyers prepare petitions demonstrating eligibility, e.g., specialty occupation for H1B. Errors in classification lead to denials. Students practice drafting visa petitions and analyzing eligibility criteria. 2.2 Grounds of inadmissibility and waivers. States exclude individuals for specific reasons. Health grounds: communicable diseases, lack of vaccinations. Criminal grounds: crimes involving moral turpitude, controlled substances, aggravated felonies. Security grounds: terrorism, espionage, foreign policy concerns. Public charge: likelihood of becoming dependent on government benefits. Waivers: discretionary forgiveness for certain grounds, e.g., I-601 waiver for hardship. Real-life example: in matter of Lopez, 2019, the Board of Immigration Appeals clarified what constitutes a crime involving moral turpitude, affecting countless admissibility determinations. A minor theft conviction could bar entry without a waiver. Practical application: lawyers screen clients for inadmissibility before filing. If grounds exist, they prepare waiver applications demonstrating extreme hardship to qualifying relatives. Students analyze criminal records to determine immigration consequences. 2.3 Removal proceedings and defense strategies. Deportation is the enforcement mechanism. Notice to appear: NTA initiates proceedings in immigration court. Defenses: cancellation of removal, asylum, adjustment of status, withholding of removal. Appeals: Board of Immigration Appeals, BIA, Federal Courts of Appeals. Real-life example: in Pereira v. Sessions, 2018, the Supreme Court held that an NTA lacking specific time and place information does not trigger the stop time rule for cancellation of removal. This procedural victory allowed many long-term residents to seek relief. Practical application: lawyers defend clients in removal proceedings, presenting evidence for defenses. Procedural errors by the government can be leveraged for termination. Students practice mock removal hearings and drafting briefs for the BIA. 3. Humanitarian protections, asylum, refugees, and special status. 3.1 Asylum and refugee status, persecution and protected grounds. Protection for those fleeing harm. Refugee, outside country of nationality, applies abroad. Asylee, within country or at border, applies domestically. Protected grounds: race, religion, nationality, political opinion, particular social group. Well-founded fear, subjective and objective component. Real-life example: in matter of AB, 2018, the Attorney General limited asylum claims based on domestic violence, narrowing the particular social group definition. This policy shift affected thousands of pending cases, illustrating the volatility of humanitarian protections. Practical application: lawyers gather evidence of persecution, country reports, affidavits. Credibility is crucial. Students practice preparing asylum applications and conducting client interviews to elicit detailed narratives. 3.2 Temporary protected status, TPS, and humanitarian parole. Discretionary protections for specific groups. TPS, for nationals of countries facing armed conflict or natural disaster. Humanitarian parole, discretionary entry for urgent humanitarian reasons or significant public benefit. Limitations: temporary, does not lead to permanent residence directly. Real-life example: TPS designations for countries like Syria and Venezuela allow nationals to work and remain safely in the U.S. Litigation often arises when administrations attempt to terminate TPS, Ramos versus Nielsen, arguing reliance interests. Practical application: lawyers monitor Federal Register for designations. They advise clients on maintaining status and exploring permanent options. Students analyze TPS eligibility criteria and termination challenges. 3.3 Special Immigrant Juvenile Status, SIJS, and Violence Against Women Act, VAWA. Protections for vulnerable populations. SIJS, for abused, abandoned, or neglected children, requires state court findings. VAWA, self-petitioning for abused spouses/children of citizens or LPRs without abusers' knowledge. Confidentiality, protections against disclosure to abusers. Real-life example: in matter of MAM, 2011, BIA clarified competency standards for children in proceedings, impacting SIJS cases. VAWA petitions allow victims to escape abuse without relying on the abuser for status. Practical application: lawyers coordinate with family courts for SIJS findings. They handle VAWA petitions sensitively to ensure safety. Students practice drafting SIJS predicate orders and VAWA declarations. 4. Contemporary issues and professional preparation. 4.1 Enforcement policies, detention, raids, and interior enforcement. Immigration enforcement strategies vary by administration. Detention, mandatory versus discretionary, bond hearings. Raids, workplace enforcement, home arrests. Sanctuary policies, local limitations on cooperation with federal authorities. Real-life example: in Jennings v. Rodriguez, 2018, the Supreme Court addressed bond hearings for detained immigrants, highlighting due process concerns in prolonged detention. Enforcement priorities shift with political changes. Practical application: lawyers file bond motions and challenge detention conditions. They advise clients on rights during encounters with enforcement. Students analyze detention statistics and policy memos. 4.2 Citizenship and naturalization, pathways and barriers. The ultimate goal for many immigrants. Requirements: continuous residence, good moral character, language/civics test. Denaturalization, rare but possible for fraud or illegal procurement. Dual citizenship, permitted by U.S. but depends on home country. Real-life example: in Maslnjak v. United States, 2017, the court held that trivial lies during naturalization do not justify denaturalization unless they influence the decision. This protects citizens from retroactive punishment. Practical application: lawyers prepare naturalization applications, addressing potential bars, e.g., past criminal conduct. Students practice conducting naturalization interviews and analyzing good moral character issues. 4.3 Learning outcomes and competency benchmarks. By completing immigration law, students should be able to navigate visa categories and eligibility requirements, defend clients in removal proceedings, prepare humanitarian protection applications, advise on citizenship and enforcement risks. Practical application: these outcomes are essential for immigration practice, human rights work, and corporate sponsorship. Students should master the Immigration and Nationality Act, INA. 4.4 Assessment methods, case simulations, petition drafting, and policy analysis. Assessments include case simulations, mock asylum interviews and removal hearings. Petition drafting, visa petitions, waivers, naturalization applications. Policy analysis, critique enforcement memos and statutory reforms. Real-life example: a final project might involve representing a hypothetical client facing deportation due to a criminal conviction, requiring analysis of waivers and defenses. This mirrors real practice. Practical application: students should practice client counseling and procedural navigation. 4.5 Transition to advanced courses, Immigration Foundations for Human Rights and Administrative Law. Immigration law intersects with multiple fields. Advanced courses, international human rights, administrative law build on these concepts. Practice, immigration involves litigation, counseling, and advocacy. Practical application, students should view immigration law as a dynamic field. Mastery ensures effective representation of vulnerable populations. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law. 210, Evidence Law. Foundations of Evidence, Relevance, Materiality, and Competency. 1.1 The purpose of evidence law, truth-seeking versus policy constraints. Evidence law governs what information fact-finders, judges or juries, may consider. Its primary goal is accurate fact-finding, but it balances this with other policies like fairness, efficiency, and privilege. Truth-seeking, admitting all relevant probative information. Exclusionary rules, preventing unreliable or prejudicial information, e.g., hearsay, character evidence. Efficiency, avoiding waste of time and confusion of issues. Real-life example, in Old Chief v. United States, 1997, the Supreme Court held that a defendant's offer to stipulate to a prior conviction status should be accepted to prevent unfair prejudice from detailed evidence of the prior crime. This illustrates the balance between probative value and prejudice. Practical application, lawyers must argue relevance under Rule 401 and prejudice under Rule 403. Students practice making offers of proof and objections during trial simulations. 1.2 Relevance and materiality, the threshold for admissibility. Evidence must be relevant to be admissible. Relevance, evidence having any tendency to make a fact more or less probable, Rule 401. Materiality, fact must be of consequence to the determination of the action. Conditional relevance, evidence relevant upon fulfillment of a condition of fact, Rule 104, b. Real-life example, in a negligence case, evidence of a defendant's speed is relevant to breach of duty. Evidence of their music preference is irrelevant unless it distracted them. Materiality ensures the fact matters to the legal claim. Practical application, lawyers foundation evidence by connecting it to elements of the claim. Students analyze fact patterns to determine relevance and materiality. 1.3 Judicial control and discretion, managing the trial process. Judges act as gatekeepers. Rule 403 Balancing, exclude if probative value substantially outweighed by danger of unfair prejudice, confusion, or waste of time. Limiting instructions, jury told to consider evidence for limited purpose. Preliminary questions, judge decides admissibility issues, Rule 104. Real-life example, in United States v. Abel, 1984, the court allowed evidence of witness bias despite prejudice, showing judicial discretion in balancing values. Judges manage the flow to ensure fair trials. Practical application, lawyers draft motions in limine to exclude prejudicial evidence before trial. Students practice arguing Rule 403 balances. 2. Hearsay and exceptions, reliability and necessity. 2.1 The hearsay rule, definition and rationale. Hearsay is an out-of-court statement offered for the truth of the matter asserted. Definition, statement, oral, written, assertive conduct, made outside current trial. Rationale, declarant not subject to cross-examination, jury cannot observe demeanor, risk of fabrication. Non-hearsay, offered for effect on listener, not truth, e.g., notice, state of mind. Real-life example, in Crawford v. Washington, 2004, the court held that testimonial hearsay violates the Confrontation Clause unless declarant is unavailable and defendant had prior opportunity for cross-examination. This constitutionalized hearsay limits in criminal cases. Practical application, lawyers identify hearsay and seek exceptions. Students practice distinguishing hearsay from non-hearsay uses. 2.2 Hearsay exceptions, reliability indicia. Numerous exceptions exist where reliability is presumed. Present sense impression, statement describing event while perceiving it. Excited utterance, statement under stress of exciting event. Business records, regularly conducted activity records. Public records, government agency records. Former testimony, given under oath in prior proceeding. Real-life example, in United States v. Iron Shell, 1980, a child's statement to a doctor shortly after assault was admitted as an excited utterance. The stress guaranteed trustworthiness. Practical application, lawyers lay foundations for exceptions, e.g., custodian testimony for business records. Students practice drafting hearsay exception analyses. 2.3 Confrontation Clause and criminal cases. Sixth Amendment limits hearsay in criminal trials. Testimonial versus non-testimonial, only testimonial hearsay triggers Confrontation Clause. Unavailability, must show declarant cannot testify. Prior cross-examination, must have had opportunity to cross. Real-life example, in Davis v. Washington, 2006, 911 calls during ongoing emergency were non-testimonial, statements after security secured were testimonial. This distinction determines admissibility. Practical application, prosecutors must ensure witnesses are available or fit exceptions. Defense counsel object to testimonial hearsay. Students analyze confrontation issues in criminal scenarios. 3. Witnesses, privileges, and expert testimony. 3.1 Witness competency and impeachment. Rules govern who can testify and how to challenge credibility. Competency, personal knowledge, oath, capacity, Rules 601 to 603. Impeachment, bias, contradiction, character for truthfulness, prior inconsistent statements. Rehabilitation, explaining inconsistencies, supporting character. Real-life example, in United States v. Abel, membership in a prison gang was admissible to show bias. Impeachment is crucial for challenging witness reliability. Practical application, lawyers prepare witnesses for direct and cross. Students practice impeachment techniques using prior statements. 3.2 Privileges, confidentiality and policy protections. Privileges protect relationships from disclosure. Attorney-client, confidential communications for legal advice. Spousal, testimonial and communications privileges. Doctor-patient/psychotherapist, medical confidentiality. Work product, attorney mental impressions. Real-life example, in Upjohn Company v. United States, 1981, the court expanded attorney-client privilege to corporate employees communicating with counsel for legal advice. This protects corporate compliance. Practical application, lawyers assert privileges to protect client information. Students analyze waiver issues and scope. 3.3 Expert testimony and scientific evidence. Experts assist fact-finders with specialized knowledge. Daubert standard, expert testimony must be reliable and relevant, Rule 702. Factors, testing, peer review, error rates, acceptance. General acceptance, Frye standard, still used in some states. Real-life example, in Daubert v. Merrill Dow Pharmaceuticals, 1993, the court established the federal standard for scientific evidence, requiring judges to act as gatekeepers. This prevents junk science in court. Practical application, lawyers qualify experts and challenge methodologies. Students practice Daubert motions and expert examinations. 4. Documentary and real evidence, authentication and best evidence. 4.1 Authentication and identification. Evidence must be shown to be what it claims. Methods, witness testimony, distinctive characteristics, chain of custody. Self-authenticating, public documents, certified copies, newspapers. Digital evidence, emails, social media posts require specific authentication. Real-life example, in United States v. Vayner, 2014, a Facebook profile was authenticated through witness testimony regarding its creation and content. Digital authentication is increasingly critical. Practical application, lawyers establish chains of custody for physical evidence. Students practice authenticating documents and digital files. 4.2 Best evidence rule, originals and copies. Prove content of writings with originals. Rule 1002, original required to prove content. Exceptions, lost/destroyed, opponent possession, collateral issues. Copies, admissible if no genuine question of authenticity. Real-life example, in United States v. Duffy, 1970, testimony about a shirt's label was excluded without the shirt itself. The rule ensures accuracy in document content. Practical application, lawyers produce originals or explain absence. Students analyze best evidence applications. 4.3 Judicial notice and presumptions. Courts accept certain facts without proof. Judicial notice, facts not subject to reasonable dispute, e.g., gravity, dates. Presumptions, shift burden of production or persuasion, e.g., legitimacy of birth. Inferences, permissible conclusions from facts. Real-life example, courts take judicial notice of public records and scientific laws. This streamlines trials by avoiding proof of undisputed facts. Practical application, lawyers request judicial notice to save time. Students analyze presumption effects. Assessment and professional preparation in evidence law. 5.1 Learning outcomes and competency benchmarks. By completing evidence law, students should be able to apply relevance and hearsay rules to factual scenarios. Assert and challenge privileges. Qualify expert witnesses and authenticate evidence. Navigate constitutional constraints, confrontation clause. Practical application, these outcomes are essential for litigation practice. Students should master the federal rules of evidence. 5.2 Assessment methods, trial simulations, motion practice, and case briefs. Assessments include trial simulations, conduct direct and cross-examination with evidentiary objections. Motion practice, draft motions in limine and Daubert challenges. Case briefs, analyze key evidence decisions. Real-life example, a final exam might involve a transcript requiring identification of evidentiary errors. This mirrors appellate review. Practical application, students should practice objection timing and argumentation. 5.3 Transition to advanced courses, evidence foundations for litigation and procedure. Evidence law underpins all trial work. Advanced courses, trial advocacy, criminal procedure build on these concepts. Practice, evidence determines case outcomes often more than substantive law. Practical application, students should view evidence as a strategic tool. Mastery ensures effective advocacy. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.211, Land Law. Foundations of Land Law, Tenure, Ownership, and Possession. 1.1 Historical Origins, Feudalism and Modern Tenure. Land law evolves from feudal systems where all land was held from the crown. Feudal tenure, hierarchy of lords and tenants, services owed. Allodial title, absolute ownership, rare, mostly theoretical. Modern tenure, estates in land, fee simple, life estate, leasehold. Real-life example, in United States v. Fullard-Leo, 1947, the court analyzed historical land grants to determine ownership, illustrating the persistence of historical tenure concepts. Modern law simplifies these but retains estate structures. Practical application, lawyers trace title to ensure valid ownership. Students analyze historical deeds for modern validity. 1.2 Estates in land, duration and quality of ownership. Estates define the duration of rights. Fee simple absolute, maximum ownership, infinite duration. Life estate, duration of a life, reversion or remainder follows. Leasehold, possessory interest for a term, contractual relationship. Future interests, rights to possess later, reversions, remainders. Real-life example, in White v. Brown, 1947, a will granting property to my sister for her life, created a life estate, with remainder to heirs. This illustrates estate creation through testamentary instruments. Practical application: lawyers draft deeds and wills to create specific estates. Students practice classifying estates in instruments. 1.3 Possession and adverse possession, rights without title. Possession can ripen into ownership. Adverse possession: hostile, actual, open, continuous, exclusive use for statutory period. Rationale: quieting titles, rewarding productive use. Disabilities: tolling for minors, incapacitated owners. Real-life example: in Van Valkenburg v. Lutz, 1952, the court denied adverse possession where use was not sufficiently exclusive. This illustrates strict element application. Practical application: lawyers advise on boundary disputes and title risks. Students analyze adverse possession claims. 2. Conveyancing and title transfer. 2.1 Contracts for sale, formation and performance. Land transactions begin with contracts. Statute of frauds, must be in writing. Equitable conversion: buyer owns equity upon signing, seller holds legal title. Conditions: financing, inspection, title contingencies. Real-life example: in Centex Homes v. Bucher, 2004, liquidated damages clauses were enforced, illustrating remedy limitations in land contracts. Practical application: lawyers draft purchase agreements protecting client interests. Students analyze breach scenarios. 2.2 Deeds and conveyance, types and covenants. Deeds transfer title. General warranty deed, covenants of season, right to convey, against encumbrances, quiet enjoyment, warranty, further assurances. Special warranty deed, covenants only against grantors' acts. Quitclaim deed, no warranties, transfers only grantors' interest. Real-life example: in Messmer v. Yule, 1932, delivery requirements were analyzed to determine deed effectiveness. Proper execution is critical. Practical application: lawyers prepare deeds and ensure proper delivery. Students practice drafting deed clauses. 2.3 Title registration and recording systems. Protecting against competing claims. Recording acts, notice, race notice statutes. Torrens system, title registration by government, rare in U.S. Title insurance, protects against defects not found in search. Real-life example: in Sabine Production Company v. Watson, 1989, race notice principles resolved competing mortgage claims. Recording priority is essential. Practical application: lawyers conduct title searches and advise on insurance. Students analyze recording act scenarios. 3. Land use controls and servitudes. 3.1 Easements and profits, non-possessory rights. Rights to use another's land. Easement appurtenant, benefits adjacent land, dominant tenement. Easement in gross, benefits person/entity, e.g., utility lines. Creation, grant, prescription, implication, necessity. Termination, merger, release, abandonment. Real-life example: in Ellenborough Park, 1956, requirements for easements were established, illustrating the need for dominant and servient tenements. Practical application: lawyers draft easement agreements and resolve disputes. Students analyze creation methods. 3.2 Covenants and equitable servitudes, private land use controls. Promises regarding land use. Real covenants, run with land at law, damages. Equitable servitudes, enforced in equity, injunctions. Requirements, touch and concern, intent, notice. HOAs, common interest communities enforce covenants. Real-life example: in Tulk v. Moxhay, 1848, equitable servitudes were established to bind successors. This enables private zoning. Practical application: lawyers advise on covenant enforcement and modification. Students analyze running requirements. 3.3 Zoning and public regulation, police power and takings. Government regulates land use. Zoning ordinances, divide areas by use, density, height. Variances and special uses, exceptions to zoning. Takings clause, compensation required for physical or regulatory takings. Real-life example, in Penn Central Transportation Company v. New York City, 1978, landmark preservation was upheld as not a taking, illustrating regulatory limits. Practical application, lawyers navigate zoning approvals and challenge takings. Students analyze regulatory takings claims. 4. Landlord-tenant law and modern issues. 4.1 Leasehold estates and covenants. Landlord-tenant relationships. Types, tenancy for years, periodic, at will, at sufferance. Implied warranty of habitability, landlord must maintain livable conditions. Remedies, rent withholding, repair and deduct, eviction. Real-life example, in Javins v. First National Realty Corporation, 1970, the warranty of habitability was recognized, shifting balance to tenants. Practical application, lawyers draft leases and handle evictions. Students analyze breach scenarios. 4.2 Mortgages and foreclosure, security interests in land. Financing land purchase. Mortgage, lien on property securing debt. Foreclosure, judicial or power of sale. Redemption, right to reclaim property after sale, statutory/equitable. Real-life example, in Rest Realty Corporation v. Cooper, 1969, constructive eviction doctrines were applied, illustrating tenant protections against mortgagee actions. Practical application, lawyers handle foreclosure defenses and loan modifications. Students analyze mortgage priority. 4.3 Contemporary issues, environmental constraints and digital property. Land law adapts to new challenges. Environmental regulations, wetlands, endangered species affecting use. Air rights and subsurface, development rights above/below ground. Digital property, virtual land rights emerging. Real-life example, in Just vs. Marinette County, 1972, environmental regulations were upheld without compensation, illustrating police power limits. Practical application, lawyers advise on environmental compliance. Students analyze emerging property concepts. V. Assessment and professional preparation in land law. 5.1 Learning outcomes and competency benchmarks. By completing land law, students should be able to analyze estates and future interests, navigate conveyancing and title systems, apply land use controls and servitudes, advise on landlord-tenant and mortgage issues. Practical application, these outcomes are essential for real estate practice. Students should master property doctrines. 5.2 Assessment methods, deed drafting, title analysis, and case studies. Assessments include deed drafting, create valid conveyances. Title analysis, identify defects and risks. Case studies, analyze land use disputes. Real-life example, a final project might involve a complex subdivision development requiring zoning and title analysis. This mirrors real estate work. Practical application, students should practice drafting and due diligence. 5.3 Transition to advanced courses, land law foundations for environmental and real estate specialization. Land law underpins related fields. Advanced courses, environmental law, real estate finance build on these concepts. Practice, property is central to wealth and development. Practical application, students should view land law as a foundational toolkit. Mastery ensures transactional success. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.212, International Humanitarian Law. Foundations of International Humanitarian Law, Origins and Principles. 1.1 Historical Development, from Solferino to Geneva. International Humanitarian Law, IHL, regulates conduct in armed conflict. Henry Dunant, witnessed Battle of Solferino, 1859, founded Red Cross. Geneva Conventions, 1864 First Treaty, 1949 4 Conventions updated. Additional protocols, 1,977 protocols expanding protections. Real-life example, the establishment of the International Committee of the Red Cross, ICRC, following Solferino illustrates the humanitarian impulse driving IHL. The 1949 conventions responded to World War II atrocities. Practical application, lawyers advise militaries and NGOs on compliance. Students analyze historical evolution for context. 1.2 Core Principles, Distinction, Proportionality, and Necessity. IHL rests on fundamental principles. Distinction, combatants versus civilians, military objectives versus civilian objects. Proportionality, attacks not causing excessive civilian harm relative to military advantage. Military necessity, force justified only to achieve legitimate military purpose. Humanity, prohibition of unnecessary suffering. Real-life example, in the Nuclear Weapons Advisory Opinion, 1996, the ICJ addressed proportionality and distinction in nuclear warfare, illustrating the limits of these principles. Practical application, lawyers assess targeting decisions for compliance. Students apply principles to hypothetical conflicts. 1.3 Classification of conflicts, international and non-international. IHL applies differently based on conflict type. International armed conflict, IAC between states, full Geneva Conventions apply. Non-international armed conflict, NIAC within state, government versus rebels, Common Article 3 and Protocol 2 apply. Occupation, territory under authority of hostile army. Real-life example, the conflict in Syria involves multiple NIACs and international interventions, complicating IHL application. Classification determines protections. Practical application, lawyers classify conflicts to determine applicable law. Students analyze conflict scenarios. 2. Protection of persons, combatants, civilians, and detains. 2.1 Combatant status and privileges. Combatants have right to participate and POW status. Criteria, command structure, uniform, carrying arms openly, respecting IHL. Privileges, immunity from prosecution for lawful acts of war. Unlawful combatants, do not meet criteria, may be prosecuted. Real-life example, in Hamdan v. Rumsfeld, 2006, the U.S. Supreme Court held that Common Article 3 applies to detainees in war on terror, illustrating status debates. Practical application, lawyers advise on detainee treatment and status determinations. Students analyze combatant criteria. 2.2 Civilian protection and direct participation. Civilians protected unless directly participating. Protection, cannot be targeted, precautions required. Direct participation, loss of protection during active involvement. Human shields, prohibited use of civilians to shield military objectives. Real-life example, in Prosecutor v. Todic, 1995, the ICTY defined armed conflict and civilian protection, shaping modern IHL jurisprudence. Practical application, lawyers investigate violations against civilians. Students analyze direct participation thresholds. 2.3 Prisoners of war and detainees, rights and treatment. Detainees entitled to humane treatment. POW rights, accommodation, food, communication, no coercion. Geneva Convention 3, specific protections for POWs. Internees, civilian detainees protected under Convention 4. Real-life example, the Abu Ghraib scandal highlighted violations of detainee treatment obligations, leading to reforms and accountability measures. Practical application, lawyers monitor detention conditions and advocate for rights. Students analyze treatment standards. 3. Means and methods of warfare, weapons and tactics. 3.1 Prohibited weapons, chemical, biological, and nuclear. Certain weapons banned due to indiscriminate or cruel effects. Chemical/biological, Chemical Weapons Convention, Biological Weapons Convention. Landmines, Ottawa Treaty bans anti-personnel mines. Cluster munitions, Convention on Cluster Munitions. Nuclear, debated legality, non-proliferation treaties. Real-life example, the use of chemical weapons in Syria led to international condemnation and OPCW investigations, illustrating enforcement mechanisms. Practical application, lawyers advise on weapons compliance and investigate use. Students analyze treaty obligations. 3.2 Perfidy and ruses, deception in war. Deception regulated to maintain trust. Perfidy, feigning protected status, e.g., white flag, to kill, prohibited. Ruses, legitimate deception, camouflage, decoys. Espionage, spies not protected if captured. Real-life example, in United States v. List, 1948, hostage killings were condemned as perfidious acts. Distinction between ruse and perfidy is critical. Practical application, lawyers advise on rules of engagement. Students analyze deception scenarios. 3.3 Protection of cultural property and environment. Special protections for heritage and nature. Hague Convention, protects cultural property from attack. Environmental protection, prohibition of widespread, long-term damage. World Heritage Sites, enhanced protection. Real-life example, destruction of Timbuktu manuscripts in Mali led to ICC convictions for war crimes, illustrating cultural property protection. Practical application, lawyers advocate for protection of heritage sites. Students analyze environmental harm thresholds. 4. Enforcement and accountability, war crimes and tribunals. 4.1 War crimes and individual criminal responsibility. Violations entail individual liability. War crimes, serious violations of IHL, grave breaches. Command responsibility, superiors liable for subordinates' crimes if knew/should have known. Universal jurisdiction, states can prosecute war crimes regardless of location. Real-life example, in Prosecutor v. Delalic, 1998, the ICTY established command responsibility standards, holding leaders accountable. Practical application, lawyers prosecute or defend war crimes charges. Students analyze responsibility theories. 4.2 International Criminal Court and ad hoc tribunals. International mechanisms for justice. ICC, Permanent Court for Genocide, Crimes Against Humanity, War Crimes. Ad hoc tribunals, ICTY, Yugoslavia, ICTR, Rwanda. Hybrid courts, Special Court for Sierra Leone, ECCC, Cambodia. Real-life example, the ICC investigation in Ukraine illustrates contemporary enforcement efforts. Jurisdiction depends on ratification and referrals. Practical application, lawyers practice before international tribunals. Students analyze jurisdictional issues. 4.3 Domestic implementation and compliance. States must implement IHL domestically. Legislation, criminalizing war crimes in national law. Training, military instruction on IHL. Advisors, legal advisors in armed forces. Real-life example, the U.S. War Crimes Act implements Geneva Conventions domestically, allowing prosecution of violations. Practical application, lawyers draft implementing legislation. Students analyze compliance mechanisms. V. Assessment and professional preparation in international humanitarian law. 5.1 Learning outcomes and competency benchmarks. By completing international humanitarian law, students should be able to classify armed conflicts and apply relevant treaties. Analyze protection of persons and objects. Evaluate means and methods of warfare. Navigate enforcement and accountability mechanisms. Practical application, these outcomes are essential for international law, military justice, and human rights practice. Students should master the Geneva Conventions. 5.2 Assessment methods, case studies, mock tribunals, and policy memoranda. Assessments include case studies, analyze violations in current conflicts. Mock tribunals, simulate war crimes trials. Policy memoranda, advise on rules of engagement. Real-life example, a final project might involve advising a military commander on targeting decisions under IHL. This mirrors operational law practice. Practical application, students should practice applying principles to complex scenarios. 5.3 Transition to Advanced Courses, IHL Foundations for International Criminal Law and Human Rights. IHL underpins international justice. Advanced courses, international criminal law, refugee law build on these concepts. Practice, IHL intersects with human rights and security law. Practical application, students should view IHL as a critical framework for conflict. Mastery ensures protection of vulnerable persons. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.213, Media Law. Foundations of Media Law, Free Speech, Regulation, and Responsibility. 1.1 Constitutional Protections, First Amendment and Beyond. Media law balances free expression with other interests. First Amendment, protects press and speech from government censorship. Prior restraint, presumptively unconstitutional, Neer v. Minnesota. Commercial speech, lesser protection, subject to regulation. Real-life example, in New York Times Company v. United States, 1971, Pentagon Papers, the court prohibited prior restraint on publication of classified documents, illustrating strong press protections. Practical application, lawyers defend media outlets against censorship. Students analyze prior restraint standards. 1.2 Defamation, libel, slander, and reputation rights. Protecting reputation from false statements. Libel, written defamation, slander, spoken. Public figures, must prove actual malice, knowledge of falsity or reckless disregard, New York Times v. Sullivan. Private figures, negligent standard in many jurisdictions. Defenses, truth, privilege, opinion. Real-life example, in Hustler magazine v. Falwell, 1988, the court held that public figures cannot recover for emotional distress without actual malice, protecting satire. Practical application, lawyers advise clients on publication risks and defend against claims. Students analyze malice standards. 1.3 Privacy rights, intrusion, disclosure, and false light. Protecting personal information. Intrusion, unreasonable invasion of seclusion. Public disclosure, private facts not of public concern. False light, misleading portrayal. Appropriation, unauthorized use of name/likeness. Real-life example, in Florida Star v. BJF, 1989, the court limited liability for publishing truthful information obtained lawfully, balancing privacy and press freedom. Practical application, lawyers navigate privacy claims against media. Students analyze public concern thresholds. 2. Broadcasting and digital media regulation. 2.1 Broadcast regulation, FCC and licensing. Broadcast media subject to greater regulation due to spectrum scarcity. FCC authority, licenses, content rules, indecency, obscenity. Fairness doctrine, abolished but historical context relevant. Equal time, political candidate access. Real-life example, in FCC v. Pacifica Foundation, 1978, the court upheld regulation of indecent speech on radio, illustrating broadcast. Practical application, lawyers advise broadcasters on compliance. Students analyze FCC regulations. 2.2 Internet and Social Media, Section 230 and Platform Liability. Digital media faces distinct rules. Section 230 CDA, platforms not liable for user content, can moderate. Copyright, DMCA safe harbors for takedown. Section 230 Reform, ongoing debates on immunity. Real-life example, in Zurin v. America Online Incorporated, 1997, Section 230 immunity was broadly interpreted, enabling Internet growth. Recent cases challenge scope. Practical application, lawyers advise platforms on moderation and liability. Students analyze Section 230 applications. 2.3 Intellectual property in media, copyright and licensing. Media relies on IP protection. Copyright protects content, articles, videos, music. Licensing, rights to use third-party content. Fair use, exceptions for news, commentary. Real-life example, in Associated Press vs. Meltwater, 2013, news clipping services were found to infringe copyright, illustrating licensing needs. Practical application, lawyers negotiate licenses and defend infringement claims. Students analyze fair use factors. 3. Access to information and government secrecy. 3.1 Freedom of Information Acts, public access. Laws enabling access to government records. FOIA, U.S. presumption of openness, exemptions, national security, privacy. State laws, varying openness standards. Journalist privilege, protection of sources, qualified. Real-life example, in New York Times Company v. DOJ, 2013, courts balanced FOIA requests against national security exemptions, illustrating transparency limits. Practical application, lawyers file FOIA requests and litigate denials. Students analyze exemption claims. 3.2 Shield laws and confidential sources. Protecting journalistic sources. Federal Shield law, proposed but not enacted, circuit split. State Shield laws, varying protections. Contempt, journalists jailed for refusing to testify. Real-life example, in Brandsburg vs. Hayes, 1972, the court limited reporters' privilege in grand jury proceedings, highlighting federal gaps. Practical application, lawyers advise journalists on source protection. Students analyze privilege scopes. 3.3 National security and classified information. Tensions between press and security. Espionage Act, prosecution for leaking classified info. Prior restraint, high bar for blocking publication. Whistleblowers, protections and limitations. Real-life example, the prosecution of Edward Snowden illustrates the conflict between disclosure and security laws. Practical application, lawyers defend leakers and advise on classification. Students analyze national security claims. 4. Contemporary issues and professional preparation. 4.1 Disinformation and fake news, legal and ethical challenges. Combating false information. Regulation, limits on government control of speech. Platform policies, private moderation rules. Defamation, claims against purveyors of fake news. Real-life example, lawsuits against conspiracy theorists, e.g., Sandy Hook cases, illustrate defamation remedies for disinformation. Practical application, lawyers advise on content moderation and defend against claims. Students analyze disinformation impacts. 4.2 Artificial intelligence and media, deepfakes and automation. Technology creates new risks. Deepfakes, manipulated media, defamation and fraud risks. AI generation, copyright ownership of AI content. Disclosure, requirements to label AI content. Real-life example, deepfake pornography cases highlight privacy and defamation harms. Legislation emerging to address this. Practical application, lawyers navigate AI liability. Students analyze emerging regulations. 4.3 Learning outcomes and competency benchmarks. By completing media law, students should be able to navigate First Amendment and defamation standards. Advise on broadcasting and digital regulation. Handle access to information requests. Address contemporary issues, disinformation, AI. Practical application, these outcomes are essential for media counsel, journalism, and tech policy. Students should master communication law. 4.4 Assessment methods, case briefs, policy papers, and simulations. Assessments include: case briefs, analyze key media decisions. Policy papers, propose regulatory reforms. Simulations, mock defamation trials. Real-life example, a final project might involve advising a newsroom on publishing sensitive documents. This mirrors real counsel work. Practical application, students should practice balancing rights and risks. 4.5 Transition to advanced courses, media law foundations for technology and constitutional law. Media law intersects with multiple fields. Advanced courses, cyber law, constitutional law build on these concepts. Practice, media law is vital for information economy. Practical application, students should view media law as a dynamic field. Mastery ensures effective advocacy for press and platforms. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.214, Sports Law. Foundations of Sports Law, Governance, Structure, and Authority. 1.1 Legal Structure of Sports Organizations. Sports governed by private associations. Leagues, NFL, NBA, FIFA, IOC, private entities with monopoly power. Teams, franchises, corporate structures. Players' associations, unions representing athletes. Real-life example, in American Needle v. NFL, 2010, the Supreme Court held the NFL is not a single entity for antitrust purposes, illustrating the complex legal structure of leagues. Practical application, lawyers advise leagues on governance and antitrust compliance. Students analyze organizational structures. 1.2 Contract law in sports, player agreements and endorsements. Contracts define relationships. Player contracts, salary, term, guarantees, options. Endorsements, image rights, exclusivity, morality clauses. Standard contracts, league-wide collective bargaining agreements, CBAs. Real-life example, in Mackey v. NFL, 1976, the Rozelle Rule was struck down as antitrust violation, freeing player movement. Contracts shape labor relations. Practical application, lawyers negotiate player and endorsement deals. Students draft contract clauses. 1.3 Agency and representation, agents and fiduciary duties. Agents represent athletes. Certification, league requirements, e.g., NBPA. Fiduciary duties, loyalty, confidentiality, best interests. Regulation, state and federal laws, Sparta. Real-life example, in Athletes Action v. NFL, 1984, agent regulation was upheld to protect players. Fiduciary breaches lead to sanctions. Practical application, lawyers certify as agents and advise on representation. Students analyze agency agreements. 2. Labor law and collective bargaining in sports. 2.1 Collective bargaining agreements, negotiation and enforcement. CBAs govern league-labor relations. Negotiation, good faith bargaining between league and union. Terms, salary caps, revenue sharing, draft, free agency. Enforcement, grievance arbitration. Real-life example, the 2011 NBA lockout resulted from CBA expiration, illustrating labor leverage. CBAs stabilize leagues. Practical application, lawyers negotiate CBAs and handle grievances. Students analyze CBA provisions. 2.2 Antitrust law in sports, monopolies and restraints. Sports leagues face antitrust scrutiny. Monopoly power, leagues often single entities in market. Restraints, drafts, salary caps, blackouts. Exemptions, baseball's antitrust exemption, Federal Baseball Club. Real-life example, in Brown v. Pro Football Incorporated, 1996, labor exemption shielded NFL from antitrust claims during impasse. Labor law intersects with antitrust. Practical application, lawyers challenge or defend restraints. Students analyze antitrust claims. 2.3 Discrimination and equality in sports. Ensuring fair access. Title IX, Gender equity in education/sports. Race and ethnicity, diversity initiatives, discrimination claims. Disability, ADA accommodations for athletes and fans. Real-life example, in NCAA v. Smith, 1999, Title IX application to NCAA was limited, illustrating scope debates. Equality remains a priority. Practical application, lawyers enforce equality rights. Students analyze discrimination claims. 3. Torts, liability, and risk management. 3.1 Injury and liability, assumption of risk. Athletes assume inherent risks. Assumption of risk, bar to recovery for inherent dangers. Negligence, liability for unreasonable conduct. Intentional torts, battery for excessive force. Real-life example, in Hackbert v. Cincinnati Bengals, 1979, on-field violence was held actionable, limiting assumption of risk. Safety is paramount. Practical application, lawyers handle injury claims and waivers. Students analyze liability standards. 3.2 Doping and anti-doping regulations. Preserving integrity. WADA Code, Global Anti-Doping Standards. Sanctions, suspensions, bans, stripping titles. Due process, arbitration, CAS, for appeals. Real-life example, the Russian doping scandal led to Olympic bans, illustrating enforcement severity. Due process required. Practical application, lawyers defend athletes in doping hearings. Students analyze anti-doping rules. 3.3 Intellectual property in sports, trademarks and broadcasting. Protecting commercial value. Trademarks, team names, logos. Broadcasting rights, major revenue source. Image rights, athlete likeness protection. Real-life example, in CBS v. NCAA, 1984, broadcasting rights were deregulated, increasing competition. IP drives revenue. Practical application, lawyers negotiate broadcasting deals. Students analyze IP protections. 4. Contemporary issues and professional preparation. 4.1 Gambling and sports betting, regulation and integrity. Legalization changes landscape. PASPA overturn, Murphy v. NCAA, 2018, allowed state betting. Integrity, match-fixing concerns, data rights. Regulation, state licensing and oversight. Real-life example, post-Murphy, states rapidly legalized betting, creating new compliance needs. Integrity units monitor games. Practical application, lawyers advise on betting compliance. Students analyze regulatory frameworks. 4.2 College sports and NIL, name, image, likeness. Changing amateurism. Nil rights, athletes can profit from identity. NCAA rules, evolving regulations. Employment status, debate on employee classification. Real-life example, in NCAA v. Alston, 2021, the court limited NCAA compensation restrictions, opening nil opportunities. Amateurism redefined. Practical application, lawyers advise athletes on nil deals. Students analyze employment issues. 4.3 Learning outcomes and competency benchmarks. By completing sports law, students should be able to navigate sports governance and contracts. Apply labor and antitrust law to sports. Handle liability and doping issues. Advise on gambling and nil rights. Practical application, these outcomes are essential for sports representation and league counsel. Students should master sport-specific regulations. 4.4 Assessment methods, contract negotiation, case analysis, and policy papers. Assessments include contract negotiation, simulate player deals. Case analysis, brief key sports decisions. Policy papers, analyze NIL or betting reforms. Real-life example, a final project might involve negotiating a nil agreement for a student athlete. This mirrors emerging practice. Practical application, students should practice negotiation and compliance. 4.5 Transition to advanced courses, Sports Law Foundations for Entertainment and Business Law. Sports law intersects with broader fields. Advanced courses, entertainment law, business associations build on these concepts. Practice, sports law is a niche but growing field. Practical application, students should view sports law as a business toolkit. Mastery ensures representation success. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.215, Comparative Law. Foundations of Comparative Law, Methodology and Purpose. 1.1 Defining Comparative Law, Description, Evaluation, and Harmonization. Comparative law studies differences and similarities between legal systems. Description, Understanding foreign laws. Evaluation, Assessing effectiveness of rules. Harmonization, Unifying laws across borders, e.g., EU, UNCITRAL. Real-life example, the UN Convention on Contracts for the International Sale of Goods, CISG, harmonizes sales law, illustrating harmonization goals. Comparative analysis informs drafting. Practical application, lawyers use comparative law for transnational transactions and reform. Students analyze foreign legal systems. 1.2 Legal families, common law, civil law, and others. Grouping systems by shared features. Common law, case-based, adversarial, precedent, UK, US, Commonwealth. Civil law, code-based, inquisitorial, scholarly, Europe, Latin America. Religious law, Sharia, canon, Hindu law influences. Mixed systems, combinations, e.g., South Africa, Louisiana. Real-life example, in Donahue v. Stevenson, 1932, the neighbor principle established negligence in common law. Civil law uses general clauses for similar outcomes. Family distinctions shape reasoning. Practical application, lawyers identify legal family to predict outcomes. Students classify systems. 1.3 Comparative methodology, functionalism and context. How to compare effectively. Functionalism, compare solutions to same problem, not just rules. Context, consider social, economic, political background. Micro versus macro, specific rules versus entire systems. Real-life example, comparing consumer protection, common law uses torts, civil law uses codes. Functionalism finds equivalent protections. Practical application, lawyers apply functionalism to transnational issues. Students practice comparative analysis. 2. Substantive comparisons, contracts, torts, and constitutional law. 2.1 Contract law, formation and enforcement. Variations in agreement rules. Consideration, required in common law, not in civil law. Good faith, implied in civil law, limited in common law. Remedies, specific performance common in civil law, damages in common law. Real-life example, in civil law, a promise may be binding without consideration, in common law, it requires exchange. This affects cross-border contracts. Practical application, lawyers draft contracts specifying governing law. Students analyze formation differences. 2.2 Tort law, liability and compensation. Approaches to harm. Fault versus strict liability, varies by system. Damages, punitive damages rare in civil law, common in U.S. Social Security, some systems replace tort with state compensation. Real-life example, New Zealand's accident compensation scheme replaces tort for personal injury, illustrating alternative models. Practical application, lawyers assess liability risks across jurisdictions. Students analyze compensation schemes. 2.3 Constitutional Law, Rights and Review. Structural differences. Judicial review, strong in U.S., varied in Europe, constitutional courts. Rights, enumerated versus unwritten principles. Federalism, division of power varies. Real-life example, Germany's Federal Constitutional Court reviews laws abstractly, U.S. Supreme Court reviews cases. Structures affect rights protection. Practical application, lawyers navigate constitutional challenges internationally. Students compare review mechanisms. 3. Legal transplants and harmonization. 3.1 Legal transplants, borrowing and adaptation. Moving laws between systems. Voluntary, adopting successful models. Imposed, colonialism, occupation. Success factors, compatibility with local culture and institutions. Real-life example, post-communist Eastern Europe adopted Western commercial codes, but enforcement varied due to institutional capacity. Transplants require adaptation. Practical application, lawyers advise on law reform projects. Students analyze transplant success. 3.2 International harmonization, treaties and model laws. Efforts to unify law. UNCITRAL, model laws on arbitration, e-commerce. EU law, directives harmonize member state laws. Restatements, U.S. effort to clarify common law. Real-life example, the New York Convention on Arbitration facilitates enforcement globally, illustrating successful harmonization. Practical application, lawyers use model laws for drafting. Students analyze harmonization treaties. 3.3 Convergence and divergence, global trends. Systems influencing each other. Convergence, common law adopting codes, civil law using precedent. Divergence, cultural resistance to uniformity. Globalization, economic pressure for similarity. Real-life example, international commercial arbitration blends common and civil law procedures, illustrating convergence. Practical application, lawyers anticipate trends in practice. Students analyze convergence drivers. 4. Contemporary issues and professional preparation. 4.1 Comparative law in practice, transnational litigation and transactions. Practical applications. Choice of law, selecting governing law in contracts. Forum shopping, choosing favorable jurisdictions. Enforcement, recognizing foreign judgments. Real-life example, in Erie Railroad Company v. Tompkins, 1938, federal courts apply state law, illustrating domestic choice of law, international adds complexity. Practical application, lawyers strategize on jurisdiction and law. Students analyze choice of law clauses. 4.2 Cultural sensitivity and legal pluralism. Respecting diversity. Legal pluralism, multiple legal orders coexist, state, customary, religious. Cultural defense, considering cultural context in litigation. Human rights, universal norms versus cultural relativism. Real-life example, in Mabwa v. Queensland, 1992, Australian law recognized native title, accommodating indigenous legal orders. Pluralism enriches systems. Practical application, lawyers navigate pluralistic contexts. Students analyze cultural interactions. 4.3 Learning outcomes and competency benchmarks. By completing comparative law, students should be able to classify legal families and systems. Apply comparative methodology to legal problems. Analyze transplants and harmonization efforts. Navigate transnational legal issues. Practical application, these outcomes are essential for international practice and reform. Students should master comparative analysis. 4.4 Assessment methods, comparative essays, case studies, and reform proposals. Assessments include comparative essays, analyze specific doctrines across systems. Case studies, evaluate transplants. Reform proposals, draft model laws. Real-life example, a final project might involve proposing a contract law reform based on comparative analysis. This mirrors legislative work. Practical application: students should practice cross-system reasoning. 4.5 Transition to advanced courses, comparative law foundations for international and domestic practice. Comparative law enhances all practice. Advanced courses, international law, human rights build on these concepts. Practice, comparative skills vital for globalized practice. Practical application: students should view comparative law as a perspective. Mastery ensures adaptability. Slide 7. Year 2, Semester 2, Advanced Legal Studies. Course, Law.216, Cyber Law. Foundations of Cyber Law, Jurisdiction, Governance, and Definitions. 1.1 Defining Cyberspace, Legal Challenges of Virtual Environments. Cyber law addresses legal issues arising from digital technology. Borderless nature, Internet transcends physical boundaries. Anonymity, difficulty identifying actors. Speed, rapid technological change outpaces law. Real-life example, in Yahoo Incorporated v. La Ligue contre le racisme, 2006, French courts ordered Yahoo to block Nazi memorabilia access in France, illustrating cross-border enforcement challenges. Practical application: lawyers advise on compliance across jurisdictions. Students analyze jurisdictional conflicts. 1.2 Jurisdiction and choice of law in cyberspace. Determining applicable law. Personal jurisdiction, minimum contacts via website interactivity, Zippo test. Subject matter jurisdiction, federal versus state authority. Choice of law, contractual selection, most significant relationship. Real-life example, in Zippo Manufacturing Company v. Zippo.com Incorporated, 1997, the court established a sliding scale for Internet jurisdiction based on interactivity. This guides online business. Practical application: lawyers draft terms of service specifying jurisdiction. Students analyze jurisdictional tests. 1.3 Governance models, multi-stakeholderism and state control. How the Internet is regulated. Multi-stakeholder, ICANN, technical communities, civil society. State control, national firewalls, data localization. Hybrid, public-private partnerships. Real-life example, ICANN manages domain names globally, illustrating multi-stakeholder governance. State controls vary, e.g., China's Great Firewall. Practical application: lawyers engage in policy advocacy. Students analyze governance structures. 2. Data protection and privacy in the digital age. 2.1 Privacy frameworks, GDPR, CCPA, and sectoral laws. Regulating personal data. GDPR, EU comprehensive, extraterritorial, consent-based. CCPA, California consumer rights to access/delete. Sectoral, US HIPAA, health, COPPA, children, GLBA, finance. Real-life example, in Schrems 2, 2020, the EU court invalidated Privacy Shield, requiring stronger safeguards for US-EU data transfers. This impacts global business. Practical application: lawyers ensure compliance with privacy laws. Students analyze consent mechanisms. 2.2 Data breaches and security obligations. Responding to incidents. Notification laws, require informing affected individuals. Security standards, reasonable measures to protect data. Liability, negligence, statutory damages, regulatory fines. Real-life example, the Equifax breach led to massive settlements and regulatory scrutiny, illustrating breach consequences. Practical application: lawyers manage breach response and compliance. Students analyze security standards. 2.3 Surveillance and government access. Balancing security and privacy. Warrants, required for content, Fourth Amendment. Metadata, lesser protection historically. Encryption, debates on backdoors. Real-life example, in Carpenter v. United States, 2018, the court required warrants for cell site location information, extending privacy protections. Practical application, lawyers challenge surveillance and advise on compliance. Students analyze warrant requirements. 3. Cybercrime and intellectual property online. 3.1 Cybercrime, hacking, fraud, and harassment. Criminal conduct in cyberspace. Computer Fraud and Abuse Act, CFAA unauthorized access. Identity theft, fraudulent use of personal information. Cyberstalking, online harassment. Real-life example, in United States v. Aaron Swartz, 2013, CFAA prosecution for downloading academic articles sparked debate on overcriminalization. Practical application, lawyers defend against cybercrime charges. Students analyze CFAA scope. 3.2 Intellectual property, copyright, trademarks, and domain names. Protecting digital assets. DMCA, takedown notices, safe harbors. Domain disputes, UDRP for cybersquatting. Digital rights management, anti-circumvention. Real-life example, in Perfect 10 v. Amazon, 2007, thumbnail images were fair use, illustrating online copyright limits. Practical application, lawyers handle takedowns and infringement claims. Students analyze DMCA processes. 3.3 Platform liability and content moderation. Responsibility for user content. Section 230, Immunity for platforms. Copyright, DMCA safe harbors. Emerging laws, EU Digital Services Act. Real-life example, ongoing debates on Section 230 reform illustrate tension between free speech and accountability. Practical application, lawyers advise platforms on moderation. Students analyze liability frameworks. 4. Contemporary issues and professional preparation. 4.1 Artificial intelligence and algorithmic accountability. Regulating AI. Liability, who is responsible for AI decisions? Bias, discrimination in algorithms. Transparency, explainability requirements. Real-life example, EU AI Act proposes risk-based regulation, illustrating emerging frameworks. Practical application, lawyers advise on AI compliance. Students analyze liability models. 4.2 Blockchain and cryptocurrency, decentralized finance. Legal status of digital assets. Securities, SEC enforcement on ICOs. Smart contracts, enforceability of code. AML/KYC, anti-money laundering compliance. Real-life example, in SEC v. W.J. Howey Company, 1946, the Howey test applied to crypto assets, determining security status. Practical application, lawyers navigate crypto regulations. Students analyze securities laws. 4.3 Learning outcomes and competency benchmarks. By completing cyber law, students should be able to navigate jurisdiction and governance issues. Advise on data protection and privacy. Handle cybercrime and IP matters. Address emerging tech, blockchain. Practical application, these outcomes are essential for tech counsel and policy. Students should master digital regulations. 4.4 Assessment methods, compliance audits, policy drafting, and case analysis. Assessments include compliance audits, evaluate privacy programs. Policy drafting, write terms of service. Case analysis, brief key cyber decisions. Real-life example, a final project might involve drafting a data breach response plan. This mirrors incident management. Practical application, students should practice technical and legal integration. 4.5 Transition to advanced courses, cyber law foundations for technology and intellectual property law. Cyber law underpins tech practice. Advanced courses, IP law, privacy law build on these concepts. Practice, Cyber law is central to digital economy. Practical application, students should view cyber law as a critical competency. Mastery ensures relevance in modern practice. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.301, Health Law. Foundational Frameworks of Health Law, Ethics, Rights, and Regulatory Structures. 1.1 The intersection of law, medicine, and ethics. Health law operates at the complex convergence of legal doctrine, medical practice, and ethical theory. Unlike traditional legal fields, health law frequently involves life and death decisions, bodily integrity, and vulnerable populations. The foundational framework rests on 4 bioethical principles: autonomy, beneficence, non-maleficence, and justice. Legal structures translate these ethical imperatives into enforceable rights and obligations. Autonomy manifests legally as informed consent, beneficence and non-maleficence underpin malpractice standards, justice informs access to care and resource allocation. Real-life example, the case of Cruzan versus Director, Missouri Department of Health, 1990, illustrates the tension between state interests and individual autonomy. Nancy Cruzan was in a persistent vegetative state, and her parents sought to withdraw life-sustaining treatment. The Supreme Court held that competent persons have a constitutionally protected liberty interest in refusing unwanted medical treatment, but states may impose procedural safeguards, e.g., clear and convincing evidence of the patient's wishes. This decision established the legal framework for advance directives and surrogate decision-making nationwide. Practical application. Lawyers advising healthcare providers must ensure protocols respect patient autonomy while complying with state statutes. This involves drafting robust informed consent forms, establishing surrogate hierarchies, and creating compliance programs for end-of-life care. Students analyze case scenarios involving incapacitated patients to determine the legal authority for medical decisions, balancing ethical duties with statutory requirements. 1.2 Confidentiality and Privacy, HIPAA and Beyond. Patient confidentiality is a cornerstone of the therapeutic relationship and a legal requirement. The Health Insurance Portability and Accountability Act, HIPAA, in the United States sets federal standards for protecting protected health information, PHI. However, confidentiality is not absolute. Exceptions exist for public health reporting, imminent harm, and law enforcement subpoenas. Real-life example, in Tarasoff versus Regents of the University of California, 1976, the court established a duty to warn identifiable victims of threatened harm by a patient. This created an exception to therapist-patient privilege, prioritizing public safety over confidentiality. Similarly, HIPAA permits disclosure without authorization to prevent serious and imminent threats to health or safety. Practical application. Lawyers must advise clients on when disclosure is mandatory versus permissible. Breach notification rules require specific timelines and content for notifying patients and regulators following data breaches. Students practice drafting breach notification letters and analyzing whether a specific disclosure falls under HIPAA exceptions. They also explore the intersection of HIPAA with state privacy laws, which may be more stringent. 1.3 Regulatory bodies and accreditation, FDA, CDC, and Joint Commission. Healthcare is heavily regulated by federal and state agencies. The Food and Drug Administration, FDA, regulates drugs, devices, and biologics. The Centers for Disease Control and Prevention, CDC, manages public health initiatives, and the Joint Commission accredits healthcare organizations. Compliance with these bodies is often a condition of reimbursement and licensure. Real-life example, the opioid crisis led to increased FDA scrutiny of pharmaceutical marketing and prescribing practices. In United States versus Purdue Pharma, 2020, the company pleaded guilty to criminal charges for misbranding OxyContin, illustrating the severe legal consequences of regulatory noncompliance. Similarly, hospitals risk losing Medicare funding if they fail Joint Commission standards. Practical application. Lawyers represent healthcare entities in regulatory investigations, negotiate corporate integrity agreements, and defend against administrative sanctions. Students analyze FDA warning letters and learn the process for drug approval, IND, NDA. They also study the Stark Law and Anti-Kickback Statute, which prohibit financial arrangements that could influence medical judgment. 2. Liability and malpractice, standards of care and risk management. 2.1 Medical negligence, elements and proof. Medical malpractice is a specialized form of negligence requiring proof of duty, breach, causation, and damages. The standard of care is typically established through expert testimony, defining what a reasonably prudent provider would do under similar circumstances. Residential ipsa loquitur may apply in obvious cases, e.g., surgery on the wrong limb. Real-life example, in Helling v. Carey, 1974, the Washington Supreme Court held that ophthalmologists could be negligent for failing to test for glaucoma in patients under 40, even though the professional standard at the time did not require it. This case illustrates the tension between customary practice and reasonable care, showing that professional norms do not always dictate legal liability. Practical application: lawyers defending malpractice claims focus on challenging the plaintiff's expert qualifications and causation theories. Plaintiff's counsel must secure credible experts willing to testify against colleagues. Students practice drafting expert retention letters and analyzing medical records to identify deviations from standards of care. They also learn about damage caps and statutory limitations on malpractice suits. 2.2 Informed consent, disclosure and capacity. Providers must disclose material risks, benefits, and alternatives to treatment. The standard for disclosure varies: physician-based, what doctors typically disclose, versus patient-based, what a reasonable patient would want to know. Capacity to consent requires understanding, appreciation, reasoning, and choice. Real-life example, in Canterbury v. Spence, 1972, the D.C. Circuit adopted the patient-centered standard for informed consent, requiring disclosure of risks that a reasonable person would consider significant. This shifted the focus from professional custom to patient autonomy. Cases involving minors or incapacitated adults require surrogate consent, adding layers of complexity. Practical application: lawyers review consent forms for adequacy and advise on documentation practices. In litigation, they analyze whether the undisclosed risk actually materialized and whether the patient would have declined treatment had they known. Students role-play consent discussions to understand the communication requirements and legal pitfalls. 2.3 Institutional liability and corporate negligence. Hospitals and healthcare systems can be directly liable for corporate negligence, independent of employee actions. This includes failing to credential physicians adequately, maintaining unsafe facilities, or implementing flawed policies. Vicarious liability, respondeat superior, also applies to employees acting within the scope of employment. Real-life example, in Darling v. Charleston Community Memorial Hospital, 1965, the court held a hospital liable for failing to review a physician's work adequately. This established the doctrine of corporate negligence, forcing institutions to oversee quality of care actively. Modern cases extend this to staffing levels and equipment maintenance. Practical application: lawyers advise hospitals on risk management protocols, credentialing committees, and policy development. They defend institutions in systemic liability cases. Students analyze hospital bylaws and credentialing files to identify potential liability exposures. They also study the impact of independent contractor status on vicarious liability. 3. Access to care and public health law. 3.1 Healthcare financing, insurance, Medicare, and Medicaid. Access to care is heavily influenced by financing structures. Private insurance, Medicare, elderly/disabled, and Medicaid, low income, create complex reimbursement landscapes. The Affordable Care Act, ACA, expanded coverage but remains subject to legal challenges. Fraud and abuse laws govern billing practices. Real-life example, in NFIB v. Sebelius, 2012, the Supreme Court upheld the ACA's individual mandate as a tax but limited the Medicaid expansion, making it optional for states. This decision shaped the landscape of healthcare access across the U.S., creating coverage gaps in non-expansion states. Legal challenges continue regarding subsidies and mandates. Practical application: lawyers navigate coverage denials, appeal administrative decisions, and advise on compliance with billing regulations. They represent providers in False Claims Act investigations. Students analyze insurance policies and Medicare regulations to determine coverage eligibility. They also study the legal implications of value-based care models. 3.2 Public Health Powers: quarantine, vaccination, and reporting. State police powers allow regulation to protect public health. This includes mandatory vaccination, quarantine during epidemics, and disease reporting. These powers conflict with individual liberties, requiring constitutional balancing. Real-life example: in Jacobson v. Massachusetts, 1905, the Supreme Court upheld mandatory smallpox vaccination, establishing the state's authority to protect public health even against individual objections. During the COVID-19 pandemic, this precedent was cited to justify mask mandates and business closures, though later cases, Roman Catholic Diocese v. Cuomo, limited restrictions on religious gatherings. Practical application: lawyers advise government agencies on the scope of emergency powers and represent individuals challenging restrictions. They draft public health orders ensuring constitutional compliance. Students analyze emergency declarations and evaluate the proportionality of public health measures. They also study international health regulations regarding cross-border disease control. 3.3 Reproductive rights and bioethics. Reproductive health involves sensitive legal and ethical issues, including abortion, contraception, sterilization, and assisted reproduction. Laws vary significantly by jurisdiction and are subject to constitutional interpretation. Real-life example: in Dobbs v. Jackson Women's Health Organization, 2022, the Supreme Court overturned Roe v. Wade, returning abortion regulation to the states. This created a patchwork of laws, with some states banning abortion entirely and others protecting it constitutionally. Legal challenges now focus on interstate travel, medication abortion, and emergency care exceptions. Practical application: lawyers advise clinics on compliance with state laws and represent patients seeking care. They navigate conflicts between state bans and federal protections, e.g., EMTLA. Students analyze statutory texts and case law to determine the legality of specific procedures. They also study legal issues surrounding IVF, surrogacy, and embryo disposition. 4. Contemporary issues and professional preparation. 4.1 Emerging technologies: telemedicine, genetics, and AI. Technology transforms healthcare delivery and raises new legal questions. Telemedicine jurisdictional lines, genetics raise privacy and discrimination concerns, and AI introduces liability for algorithmic decisions. Real-life example: the Genetic Information Non-Discrimination Act, GINA, prohibits discrimination based on genetic data, but gaps remain for life insurance and long-term care. Telemedicine licensure compacts allow cross-state practice, but liability issues persist regarding standard of care in virtual settings. Practical application: lawyers draft telemedicine consent forms and advise on multi-state licensure. They handle genetic privacy claims and navigate FDA regulation of AI diagnostic tools. Students analyze terms of service for health apps and evaluate liability for AI misdiagnosis. 4.2 End-of-life decision-making in palliative care. Legal frameworks govern withdrawal of treatment, palliative sedation, and medical aid in dying. States vary on the legality of physician-assisted suicide. Advanced directives and POLST forms guide care. Real-life example: Oregon's Death with Dignity Act allows terminally ill adults to request medication to end their life. Legal challenges focus on conscience clauses for providers and protections for vulnerable populations. Courts often intervene in disputes between families and providers regarding feudal treatment. Practical application: lawyers draft advance directives and represent parties in end-of-life disputes. They advise ethics committees on futility determinations. Students analyze case law on withdrawal of nutrition and hydration. They also study the legal distinctions between withholding treatment and active euthanasia. 4.3 Learning outcomes and competency benchmarks. By completing health law, students should be able to navigate regulatory frameworks, HIPAA, FDA, ACA. Analyze malpractice and liability claims. Advise on public health powers and individual rights. Address emerging issues in technology and bioethics. Practical application. These outcomes are essential for healthcare counsel, hospital administration, and patient advocacy. Students should master the intersection of law and medicine. 4.4 Assessment methods, case studies, policy analysis, and compliance audits. Assessments include case studies, analyze malpractice and consent scenarios. Policy analysis, evaluate public health regulations. Compliance audits, review HIPAA and billing practices. Real-life example, a final project might involve conducting a mock HIPAA audit for a clinic. This mirrors compliance work. Practical application, students should practice regulatory analysis and risk assessment. 4.5 Transition to advanced courses, health law foundations for bioethics and administrative law. Health law underpins specialized practice. Advanced courses, bioethics, elder law build on these concepts. Practice, health law intersects with employment, corporate, and criminal law. Practical application, students should view health law as a dynamic regulatory field. Mastery ensures effective representation of healthcare entities and patients. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.302, International Trade Law. Foundations of International Trade Law, Systems, Institutions, and Principles. 1.1 The Global Trading System, from GATT to WTO. International trade law governs the exchange of goods and services across borders. The General Agreement on Tariffs and Trade, GATT, established in 1947, reduced tariffs and trade barriers. In 1995, the World Trade Organization, WTO, replaced GATT, providing a permanent institutional framework with dispute settlement mechanisms. The system aims to promote free trade, predictability, and development. Real-life example, the Uruguay Round, 1986 to 1994, expanded trade rules to include services, GATS, intellectual property, TRIPS, and agriculture. This created a comprehensive legal framework. The WTO's dispute settlement body has adjudicated hundreds of cases, such as U.S. Shrimp, 1998, where environmental restrictions were challenged as trade barriers. Practical application. Lawyers advise exporters and importers on compliance with WTO rules and regional agreements. They represent governments in dispute settlement proceedings. Students analyze WTO panel reports to understand interpretation of trade obligations. They also study the impact of trade rules on domestic policy space. 1.2 Core Principles, Most Favored Nation and National Treatment. Non-discrimination is the cornerstone of trade law. The Most Favored Nation, MFN, principle requires members to extend favorable treatment granted to one member to all others. National treatment requires imported goods to be treated no less favorably than domestic goods once inside the market. Real-life example, in Japan, alcoholic beverages, 1996, the WTO found Japan's tax system violated national treatment by taxing imported spirits higher than domestic shochu. This ensured equal competitive conditions. MFN prevents preferential bilateral deals that undermine the multilateral system, though exceptions exist for free trade agreements. Practical application. Lawyers assess whether domestic regulations discriminate against foreign products. They challenge protectionist measures through WTO mechanisms. Students analyze tax schemes and regulatory standards for compliance with non-discrimination principles. They also study exceptions for security and public morals. 1.3 Regional Trade Agreements, USMCA, EU, and AFCFTA. While the WTO governs global trade, regional agreements create deeper integration. The United States-Mexico-Canada Agreement, USMCA, replaced NAFTA, updating labor and environmental standards. The European Union, EU, operates as a customs union with a single market. The African Continental Free Trade Area, AFCFTA, aims to boost intra-African trade. Real-life example, the USMCA includes rules of origin requiring higher regional content for automobiles to qualify for tariff-free treatment. This influences manufacturing supply chains. The EU's single market allows free movement of goods, services, capital, and people, going beyond traditional trade agreements. Practical application: lawyers advise companies on rules of origin to maximize tariff benefits. They navigate regulatory harmonization within regions. Students compare WTO and regional obligations to identify conflicts. They also analyze the impact of regionalism on multilateral trade systems. 2. Trade remedies and barriers, tariffs, quotas, and subsidies. 2.1 Tariffs and customs classification. Tariffs are taxes on imports, classified under Harmonized System, HS, codes. Classification determines duty rates. Valuation methods, transaction value, deductive value, affect tax liability. Customs compliance is critical to avoid penalties. Real-life example, the U.S.-China trade war involved Section 301 tariffs on billions of dollars of goods. Companies had to reclassify products or shift supply chains to avoid duties. Customs disputes often center on classification disputes, e.g., is a smartwatch a clock or a computer? Practical application: lawyers classify goods and advise on duty mitigation strategies, e.g., foreign trade zones. They represent clients in customs audits and litigation. Students practice HS classification and calculate duty liabilities. They also study free trade agreement utilization. 2.2 Non-tariff barriers, standards, licensing, and quotas. Non-tariff barriers, NTBs, include technical standards, sanitary measures, and import licensing. The Agreement on Technical Barriers to Trade, TBT, and Sanitary and Phytosanitary, SPS, agreement regulate these to prevent disguised protectionism. Real-life example, in EC, Hormones, 1998, the WTO ruled against the EU's ban on hormone-treated beef, finding insufficient scientific justification under the SPS agreement. This highlighted the tension between consumer safety and trade liberalization. Quotas are generally prohibited but exist in specific sectors, e.g., textiles historically. Practical application: lawyers challenge NTBs as trade barriers. They advise on compliance with foreign standards, e.g., CE marking in Europe. Students analyze SPS measures for scientific basis. They also study labeling requirements and their trade impact. 2.3 Trade remedies, anti-dumping, countervailing duties, and safeguards. Countries may impose remedies to protect domestic industries from unfair trade. Anti-dumping duties address sales below cost. Countervailing duties offset foreign subsidies. Safeguards provide temporary relief from import surges. Real-life example: the U.S. frequently imposes anti-dumping duties on steel and aluminum from various countries. Investigations require proof of injury to domestic industry. In U.S., softwood lumber, 2004, long-standing disputes arose over Canadian subsidies and dumping allegations. Practical application: lawyers represent domestic industries petitioning for remedies or foreign exporters defending against duties. They navigate complex administrative proceedings. Students analyze injury determinations and subsidy calculations. They also study the WTO rules governing remedy imposition. 3. Trade in services and intellectual property. 3.1 General Agreement on Trade in Services, GATS. Services trade, banking, telecommunications, tourism, is governed by GATS. Modes of supply include cross-border, consumption abroad, commercial presence, and presence of natural persons. Commitments are scheduled specifically. Real-life example: in U.S., gambling, 2005, the WTO found U.S. restrictions on online gambling violated GATS commitments. This showed how domestic regulations can conflict with trade obligations. Liberalization of services is often slower than goods due to regulatory sensitivity. Practical application: lawyers advise service providers on market access commitments. They challenge discriminatory licensing requirements. Students analyze GATS schedules to determine market access. They also study professional qualification recognition. 3.2 Trade-related aspects of intellectual property rights, TRIPS. TRIPS sets minimum standards for IP protection within the trade system. It covers patents, copyrights, trademarks, and enforcement. Flexibilities exist for public health, e.g., compulsory licensing for medicines. Real-life example: the Doha Declaration, 2001, affirmed TRIPS flexibilities for access to medicines, allowing countries to issue compulsory licenses for HIV drugs. This balanced IP rights with public health needs. Enforcement provisions require criminal penalties for counterfeiting. Practical application: lawyers advise on IP compliance in export markets. They handle customs seizures of counterfeit goods. Students analyze compulsory licensing mechanisms. They also study the impact of TRIPS on technology transfer. 3.3 Digital trade and e-commerce. Modern agreements address digital trade, data flows, and localization. Restrictions on data localization and source code transfer are emerging issues. Moratoriums on customs duties on electronic transmissions are debated. Real-life example: the USMCA includes strong digital trade chapters prohibiting data localization and ensuring cross-border data flows. This supports the digital economy. WTO negotiations on e-commerce are ongoing to update global rules. Practical application: lawyers advise tech companies on cross-border data compliance. They negotiate digital trade provisions. Students analyze data localization laws. They also study jurisdictional issues in online transactions. 4. Dispute settlement and contemporary challenges. 4.1 WTO Dispute Settlement Mechanism. The WTO provides a binding dispute settlement system. Panels hear cases, the appellate body reviews legal interpretations. Remedies include withdrawal of measures or compensation. Retaliation is authorized if compliance fails. Real-life example: the appellate body crisis, since 2019, due to U.S. blocking of judge appointments has impaired the system. Members now use interim arbitration, MPA. This highlights the fragility of multilateral institutions. Practical application: lawyers litigate before WTO panels. They advise governments on compliance with rulings. Students simulate dispute settlement proceedings. They also study enforcement challenges. 4.2 Trade and environment, sustainability and climate change. Trade rules intersect with environmental goals. Carbon border adjustments, subsidies for green technology, and restrictions on environmentally harmful goods are contentious. WTO rules allow exceptions for conservation. Real-life example: the EU's Carbon Border Adjustment Mechanism, CBAM, imposes costs on imports based on carbon content. This faces WTO compatibility questions. Disputes arise over whether environmental measures are disguised protectionism. Practical application: lawyers advise on green trade measures. They defend environmental regulations against trade challenges. Students analyze the interface between trade and environmental law. They also study sustainable supply chain laws. 4.3 Learning outcomes and competency benchmarks. By completing international trade law, students should be able to navigate WTO and regional trade agreements, analyze trade remedies and barriers, advise on services and IP trade issues, litigate trade disputes. Practical application: these outcomes are essential for international business and government trade policy. Students should master trade regulations. 4.4 Assessment methods, case simulations, policy briefs, and compliance analysis. Assessments include case simulations, mock WTO panel hearings. Policy briefs, advise on trade agreements. Compliance analysis, evaluate tariff and NTB compliance. Real-life example, a final project might involve drafting a complaint for a WTO dispute. This mirrors litigation practice. Practical application, students should practice legal argumentation and policy analysis. 4.5 Transition to advanced courses, Trade Law Foundations for International Economic Law. Trade law underpins global commerce. Advanced courses, International Investment Law, Economic sanctions build on these concepts. Practice, trade law is central to globalization. Practical application, students should view trade law as a strategic tool. Mastery ensures competitive advantage. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.303, Public International Law. Foundations of Public International Law, Sources, Subjects, and Structure. 1.1 Sources of International Law, Article 38 ICJ Statute. Public international law governs relations between states and international actors. Article 38 of the International Court of Justice, ICJ, statute identifies primary sources, treaties, customary international law, general principles of law. Judicial decisions and scholarly writings are subsidiary means. Real-life example, in North Sea continental shelf cases, 1969, the ICJ analyzed whether the equidistance principle in the Geneva Convention had become customary law binding on non-parties. It held that widespread state practice and opinio juris, belief of legal obligation, are required. This illustrates the formation of custom. Practical application, lawyers identify applicable sources in transnational disputes. They argue whether a norm is customary or treaty-based. Students analyze state practice to determine custom. They also study the hierarchy of norms, e.g., jus cogens. 1.2 Subjects of international law, states, organizations, and individuals. States are the primary subjects, possessing sovereignty and legal personality. International organizations, IOs, derive personality from founding treaties. Individuals have limited personality, e.g., human rights, international criminal law. Real-life example, in reparation for injuries, 1949, the ICJ held the UN has legal personality to bring claims, even against non-members. This established IO personality. Individuals gain standing in human rights courts, e.g., ECHR, and international criminal tribunals. Practical application, lawyers determine standing before international bodies. They advise states on recognition and statehood. Students analyze criteria for statehood, Montevideo Convention. They also study the status of non-state actors, e.g., NGOs, corporations. 1.3 Sovereignty and jurisdiction, territory, nationality, and universality. Sovereignty implies exclusive authority within territory. Jurisdiction is based on territory, nationality, protective principle, or universality. Extraterritorial jurisdiction is controversial. Real-life example, in Lotus case, 1927, the PCIJ held states may exercise jurisdiction unless prohibited by international law. Modern law reverses this, jurisdiction requires a permissive rule. Universal jurisdiction allows prosecution of piracy, genocide, and torture regardless of location. Practical application, lawyers assess jurisdictional bases for prosecution or civil suits. They challenge extraterritorial application of domestic laws. Students analyze jurisdictional conflicts. They also study immunity limitations. 2. State responsibility and diplomatic relations. 2.1 State responsibility, attribution and breach. States are responsible for internationally wrongful acts. Conduct of state organs is attributable. Breach occurs when conduct violates an international obligation. Circumstances precluding wrongfulness include consent, self-defense, and force majeure. Real-life example, in Tehran hostages case, 1980, the ICJ held Iran responsible for failing to protect the U.S. Embassy, attributing conduct of militants to the state due to endorsement by leaders. This illustrates attribution rules. Reparation must wipe out consequences of the illegal act. Practical application, lawyers bring claims against states for violations. They advise on immunity and responsibility. Students analyze attribution scenarios. They also study countermeasures and sanctions. 2.2 Diplomatic and Consular Relations, Vienna Conventions. The Vienna Convention on Diplomatic Relations, 1961, governs diplomatic immunity and privileges. Missions are inviolable, diplomats are immune from criminal jurisdiction. Consular relations involve protection of nationals. Real-life example, in Lagrand case, 2001, the ICJ held the U.S. violated the Vienna Convention on Consular Relations by failing to inform German nationals of their right to consular assistance before execution. This established individual rights under the treaty. Practical application, lawyers advise embassies on immunity and privileges. They handle cases involving detained nationals. Students analyze immunity scopes. They also study abuses of diplomatic status. 2.3 Treaty Law, Formation, Interpretation, and Termination. The Vienna Convention on the Law of Treaties, VCLT, governs treaties. Formation involves consent, signature, ratification. Interpretation follows text, context, object, and purpose. Termination occurs via breach, impossibility, or fundamental change of circumstances. Real-life example, in Gapsikovo-Najamaros project, 1997, the ICJ rejected Hungary's claim that fundamental change of circumstances justified treaty termination. This shows the high threshold for rebus sic stantibus. Reservations modify legal effects but must be compatible with the treaty's object. Practical application, lawyers draft and interpret treaties. They advise on reservation compatibility. Students analyze VCLT provisions. They also study treaty conflicts and harmonization. 3. Use of force and international security. 3.1 Jus ad bellum, Prohibition and Exceptions. The UN Charter prohibits the use of force, Article 2, 4. Exceptions include self-defense, Article 51, and Security Council authorization, Chapter 7. Preemptive self-defense is controversial. Real-life example, in Nicaragua versus United States, 1986, the ICJ held U.S. support for Contras violated the prohibition on force. It clarified that self-defense requires an armed attack and must be necessary and proportional. This shapes modern use of force debates. Practical application, lawyers advise governments on legality of military action. They represent states in Security Council proceedings. Students analyze self-defense claims. They also study humanitarian intervention doctrines. 3.2 International Humanitarian Law, Conduct in Conflict. IHL regulates conduct during armed conflict, Geneva Conventions. It distinguishes combatants and civilians, protects detainees, and limits weapons. Violations constitute war crimes. Real-life example, in Nuclear Weapons Advisory Opinion, 1996, the ICJ addressed legality of nuclear weapons under IHL. It found no specific prohibition but emphasized compliance with distinction and proportionality. This illustrates IHL constraints. Practical application, lawyers advise militaries on rules of engagement. They prosecute war crimes. Students analyze IHL principles. They also study enforcement mechanisms. 3.3 International Security Council and Sanctions. The Security Council maintains peace and security. It imposes sanctions, authorizes force, and establishes tribunals. Resolutions are binding on members. Real-life example, sanctions on North Korea restrict trade and finance to curb nuclear programs. Compliance is monitored by committees. Sanctions impact human rights, raising legal debates. Practical application, lawyers advise on sanctions compliance. They challenge listings before courts. Students analyze Security Council resolutions. They also study veto power dynamics. 4. Contemporary issues and professional preparation. 4.1 International Environmental Law, Climate and Biodiversity. International law addresses global environmental challenges. Treaties include UNFCCC, Climate, CBD, Biodiversity, and UNCLOS, Oceans. Principles include common but differentiated responsibilities. Real-life example, the Paris Agreement, 2015, requires nationally determined contributions to limit warming. Compliance is based on transparency rather than enforcement. Litigation arises over state duties to protect citizens from climate harm. Practical application, lawyers advise on climate compliance and litigation. They negotiate environmental treaties. Students analyze climate obligations. They also study transboundary harm principles. 4.2 International Criminal Law, Accountability for Atrocities. International criminal law holds individuals accountable for genocide, crimes against humanity, and war crimes. The ICC prosecutes when states are unwilling or unable. Real-life example, the ICC investigation in Ukraine addresses alleged war crimes. Complementarity requires domestic prosecution first. Immunities for heads of state are limited before international tribunals. Practical application, lawyers prosecute or defend before international courts. They advise on universal jurisdiction cases. Students analyze ICC procedures. They also study truth commissions. 4.3 Learning outcomes and competency benchmarks. By completing public international law, students should be able to identify sources and subjects of international law. Analyze state responsibility and treaty obligations. Evaluate use of force and security mechanisms. Navigate contemporary global challenges. Practical application, these outcomes are essential for diplomatic service, international organizations, and NGOs. Students should master international legal frameworks. 4.4 Assessment methods, memorials, oral arguments, and policy papers. Assessments include memorials, draft written submissions for ICJ. Oral arguments, simulate court proceedings. Policy papers, analyze international crises. Real-life example, a final project might involve drafting a memorial for a territorial dispute. This mirrors international litigation. Practical application, students should practice advocacy and research. 4.5 Transition to advanced courses, Public International Law Foundations for Global Practice. Public international law underpins global relations. Advanced courses, International Human Rights, Law of the Sea build on these concepts. Practice, public international law is vital for state and non-state actors. Practical application, students should view public international law as a framework for order. Mastery ensures effective global engagement. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.304, Private International Law. Foundations of Private International Law, Conflict of Laws and Jurisdiction. 1.1 Nature and Purpose of Private International Law. Private international law, PL, or conflict of laws, resolves disputes involving foreign elements. It determines which court has jurisdiction, which law applies, and whether foreign judgments are recognized. Unlike public international law, it operates within domestic legal systems to manage cross-border private disputes. Real-life example, in a contract dispute between a U.S. company and a German supplier, PL determines if a New York court can hear the case, whether U.S. or German law governs the contract, and if a German judgment can be enforced in the U.S. This prevents forum shopping and ensures predictability. Practical application, lawyers draft forum selection and choice of law clauses to control PL outcomes. They analyze jurisdictional bases to file suits strategically. Students study the differences between common law and civil law approaches to conflicts. 1.2 Jurisdiction, personal, subject matter, and international. Jurisdiction determines the court's authority over parties and disputes. Personal jurisdiction requires contacts with the forum. Subject matter jurisdiction depends on the case type. International jurisdiction involves cross-border competence. Real-life example, in Daimler AG v. Baumann, 2014, the U.S. Supreme Court limited general jurisdiction over corporations to places where they are at home. This affects where multinational companies can be sued globally. EU regulations, Brussels I bis, provide uniform jurisdiction rules among member states. Practical application, lawyers assess jurisdictional risks for clients operating internationally. They challenge jurisdiction via motions to dismiss. Students analyze minimum contacts tests. They also study forum non-convenience doctrines. 1.3 Choice of law, lex loci, lex fori, and modern approaches. Choice of law rules select the applicable substantive law. Traditional rules use lex loci, law of the place. Modern approaches, e.g., restatement second, use most significant relationship. Party autonomy allows selection in contracts. Real-life example, in Babcock v. Jackson, 1963, New York applied its own law to a car accident in Ontario because the parties were New York residents. This shifted from rigid lex loci to flexible interest analysis. Contractual choice of law is generally upheld unless contrary to public policy. Practical application, lawyers advise on choice of law implications for transactions. They argue for favorable law application in litigation. Students analyze choice of law clauses. They also study mandatory rules that override party choice. 2. Family law and succession in cross-border contexts. 2.1 Marriage, divorce, and child custody. Cross-border family disputes involve recognition of status and custody orders. Hague Conventions address child abduction and protection. Divorce jurisdiction depends on domicile or residence. Real-life example, the Hague Convention on the Civil Aspects of International Child Abduction requires return of children wrongfully removed. In Chafin v. Chafin, 2013, the Supreme Court held appeals are not moot even if the child is returned, ensuring review. This protects custody rights. Practical application, lawyers handle international custody cases and abduction petitions. They advise on recognition of foreign divorces. Students analyze habitual residence determinations. They also study enforcement of support orders. 2.2 Succession and wills, testamentary validity and administration. Cross-border succession involves multiple jurisdictions. Wills must be valid under applicable law. Administration of estates requires coordination across borders. EU succession regulation harmonizes rules in Europe. Real-life example, a U.S. citizen owning property in France faces different succession laws, forced heirship in France versus testamentary freedom in U.S. Planning requires coordination to avoid conflicts. International wills under the Washington Convention facilitate validity. Practical application, lawyers draft international wills and advise on tax implications. They handle probate in multiple jurisdictions. Students analyze validity requirements. They also study estate administration conflicts. 2.3 Adoption and surrogacy, recognition and ethics. International adoption and surrogacy involve complex legal and ethical issues. Hague Convention on Protection of Children and Cooperation in Respect of Intercountry Adoption regulates adoptions. Surrogacy laws vary widely, creating recognition issues. Real-life example, some countries prohibit commercial surrogacy, leading to citizenship and parentage disputes for children born abroad. Courts must determine legal parentage based on conflicting laws. The Hague Convention aims to prevent trafficking and ensure best interests. Practical application, lawyers navigate adoption procedures and parentage declarations. They advise on citizenship for children born via surrogacy. Students analyze recognition criteria. They also study ethical safeguards. 3. Commercial transactions and judgment enforcement. 3.1 International contracts and arbitration. Cross-border contracts often include arbitration clauses. The New York Convention facilitates enforcement of arbitral awards globally. Choice of law and forum are critical. Real-life example, in BG Group plc vs. Republic of Argentina, 2014, the Supreme Court addressed who decides arbitrability, court or arbitrator. This impacts international investment disputes. Arbitration avoids national court biases. Practical application, lawyers draft arbitration clauses and enforce awards. They challenge enforcement on public policy grounds. Students analyze New York Convention defenses. They also study investment treaty arbitration. 3.2 Recognition and enforcement of foreign judgments. Enforcing a judgment from one country in another requires recognition procedures. Comity principles guide recognition. Grounds for refusal include lack of jurisdiction, fraud, or public policy violations. Real-life example, in Hilton v. Gio, 1895, the U.S. Supreme Court established comity standards for enforcing foreign judgments. Reciprocity may be required. EU regulations simplify enforcement among member states. Practical application, lawyers seek enforcement of foreign judgments domestically. They defend against enforcement actions. Students analyze recognition statutes. They also study asset tracing across borders. 3.3 Insolvency and cross-border bankruptcy. Cross-border insolvency requires coordination to maximize asset value. UNCITRAL model law on cross-border insolvency facilitates cooperation. Main proceedings versus non-main proceedings determine control. Real-life example, the Lehman Brothers bankruptcy involved proceedings in multiple countries. Cooperation agreements allowed efficient asset distribution. Chapter 15 of the U.S. Bankruptcy Code implements the model law. Practical application, lawyers handle cross-border bankruptcy cases. They coordinate with foreign representatives. Students analyze Chapter 15 petitions. They also study creditor priority conflicts. 4. Contemporary issues and professional preparation. 4.1 Digital transactions and cyber jurisdiction. Online activities complicate jurisdiction and choice of law. Where does a cyber tort occur? Which law governs digital contracts? Data localization laws impact cross-border flows. Real-life example, in Google v. CNIL, 2019, the EU court limited the global right to be delisted, balancing privacy and jurisdiction. This shows the limits of extraterritorial regulation. Online terms of service often specify governing law. Practical application, lawyers advise on digital jurisdiction risks. They draft terms for global platforms. Students analyze cyber tort locations. They also study data transfer regulations. 4.2 Human rights and private international law. Human rights norms influence PL. Public policy exceptions may refuse enforcement of judgments violating rights. Best interests of the child guide family law conflicts. Real-life example, courts may refuse to enforce foreign custody orders if they violate human rights standards. The ECHR influences PIL among European states. This integrates public and private international law. Practical application, lawyers argue public policy exceptions based on rights. They advise on human rights compliance in transactions. Students analyze rights-based conflicts. They also study international conventions. 4.3 Learning outcomes and competency benchmarks. By completing private international law, students should be able to determine jurisdiction and applicable law, handle cross-border family and commercial disputes, enforce foreign judgments and awards, navigate digital and human rights issues. Practical application, these outcomes are essential for international litigation and transactional practice. Students should master conflict of laws principles. 4.4 Assessment methods, case studies, drafting clauses, and enforcement simulations. Assessments include case studies, analyze jurisdictional conflicts. Drafting clauses, write forum selection and choice of law provisions. Enforcement simulations, seek recognition of foreign judgments. Real-life example, a final project might involve enforcing an arbitral award in multiple jurisdictions. This mirrors international practice. Practical application, students should practice cross-border problem solving. 4.5 Transition to advanced courses, PL Foundations for International Business and Litigation. PL underpins cross-border practice. Advanced courses, international arbitration, cross-border M&A build on these concepts. Practice, PL is vital for globalization. Practical application, students should view PL as a navigation tool. Mastery ensures cross-border success. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.305, Litigation and Advocacy. Foundations of Litigation and Advocacy, Strategy, Ethics, and Skills. 1.1 The role of the advocate, officer of the court and zealous representative. Litigation attorneys serve dual roles, zealous advocates for clients and officers of the court responsible for integrity. This tension requires balancing client interests with ethical obligations. Advocacy involves persuasion through logic, evidence, and rhetoric. Real-life example, in Nix v. Whiteside, 1986, the Supreme Court held lawyers cannot assist clients in committing perjury. This limits zealous advocacy when it conflicts with truthfulness. Effective advocates achieve results within ethical bounds. Practical application, lawyers counsel clients on realistic outcomes and ethical constraints. They maintain professionalism even in adversarial settings. Students practice ethical decision-making in simulations. They also study sanctions for misconduct. 1.2 Case theory and development, narrative and evidence. Successful litigation requires a coherent case theory, a story explaining why the client should win. Theory integrates facts, law, and themes. Evidence must support the narrative. Real-life example, in the O.J. Simpson trial, the defense theory focused on police misconduct and reasonable doubt, while the prosecution focused on forensic evidence. The defense's narrative resonated with the jury. Developing a compelling theory is crucial. Practical application, lawyers draft case theories early and adjust based on discovery. They align evidence with themes. Students practice crafting opening statements around a theory. They also study theme consistency. 1.3 Pretrial strategy, pleadings, motions, and discovery. Pretrial proceedings shape the case. Pleadings define issues. Motions can dispose of claims or limit evidence. Discovery gathers information. Strategy involves timing and scope. Real-life example, filing a motion to dismiss early can end a case cheaply. Limiting discovery through protective orders reduces costs. In Ashcroft v. Iqbal, 2009, pleading standards were tightened, affecting strategy. Practical application, lawyers draft strategic pleadings and motions. They manage discovery plans. Students practice motion drafting. They also study discovery disputes. 2. Trial advocacy, opening, examination, and closing. 2.1 Opening statements, setting the stage. Opening statements introduce the case to the fact finder. They should be credible, organized, and thematic. Avoid argument, focus on what evidence will show. Real-life example, effective openings create a roadmap. In high-profile cases, openings set the tone for media and public perception. Jurors form impressions early. Practical application, lawyers script and rehearse openings. They use visual aids. Students practice delivering openings. They also study jury psychology. 2.2 Direct and cross-examination, witness control. Direct examination elicits favorable testimony through open questions. Cross-examination controls witnesses through leading questions to impeach or limit damage. Real-life example, in United States v. McVeigh, cross-examination of witnesses was critical to establishing conspiracy. Effective cross exposes inconsistencies. Direct builds credibility. Practical application, lawyers prepare witnesses thoroughly. They plan cross-examination topics. Students practice examination techniques. They also study impeachment methods. 2.3 Closing arguments, persuasion and verdict. Closing arguments summarize evidence and argue for a verdict. They connect facts to law. Emotional appeals must be grounded in evidence. Real-life example, in Ernesto Miranda's retrial, closing arguments focused on confession voluntariness. Persuasive closings can sway close cases. Jurors recall closings during deliberations. Practical application, lawyers draft closings based on trial developments. They anticipate counterarguments. Students practice closing delivery. They also study rebuttal strategies. 3. Motion practice and appellate advocacy. 3.1 Motion practice, written and oral argument. Motions request court action. Written briefs must be clear and persuasive. Oral argument highlights key points and answers questions. Real-life example, summary judgment motions often decide cases. In Celotex Corporation v. Catrett, 1986, standards were clarified. Effective briefs anticipate judicial concerns. Practical application, lawyers draft motions and briefs. They prepare for oral argument. Students practice moot court. They also study judicial preferences. 3.2 Appellate advocacy, standards of review and briefing. Appeals focus on legal errors, not facts. Standards of review, de novo, abuse of discretion, dictate argument structure. Briefs must be concise and precise. Real-life example, in Brown v. Board of Education, appellate briefing changed constitutional law. Appellate courts rely heavily on briefs. Oral argument clarifies issues. Practical application, lawyers identify appealable issues and preserve errors. They draft appellate briefs. Students practice appellate writing. They also study record preparation. 3.3 Alternative dispute resolution in litigation context. Litigation often involves ADR. Mediation and arbitration can resolve cases efficiently. Lawyers must advise clients on ADR options. Real-life example, many courts require mediation before trial. Settlement conferences resolve most cases. ADR saves time and costs. Practical application, lawyers negotiate settlements. They represent clients in mediation. Students practice negotiation. They also study enforcement of settlements. 4. Contemporary issues and professional preparation. 4.1 Technology in litigation, e-discovery and virtual trials. Technology transforms litigation. E-discovery manages digital evidence. Virtual trials became common during the pandemic. Presentation tools enhance persuasion. Real-life example, e-discovery costs can dominate budgets. Virtual hearings require technical proficiency. Tools like Trial Director organize exhibits. Practical application, lawyers manage e-discovery protocols. They adapt to virtual platforms. Students practice tech usage. They also study privacy in discovery. 4.2 Diversity and inclusion in advocacy. Diversity improves advocacy and justice. Bias affects proceedings. Inclusive practices enhance fairness. Real-life example, jury diversity impacts verdicts. Attorney diversity improves client trust. Courts promote inclusive practices. Practical application, lawyers challenge bias. They promote diversity in teams. Students study bias impacts. They also study inclusive advocacy. 4.3 Learning Outcomes and Competency Benchmarks. By completing litigation and advocacy, students should be able to develop case theories and strategies, conduct trial examinations and arguments, draft motions and appellate briefs, utilize technology and ADR. Practical application. These outcomes are essential for litigation practice. Students should master advocacy skills. 4.4 Assessment methods, mock trials, brief writing, and oral arguments. Assessments include mock trials, simulate full trials. Brief writing, draft motions and appeals. Oral arguments, present before judges. Real-life example, a final project might involve a full mock trial with verdict. This mirrors practice. Practical application, students should practice performance and writing. 4.5 Transition to advanced courses, advocacy foundations for specialized litigation. Advocacy underpins all litigation. Advanced courses, complex litigation, criminal trial practice build on these concepts. Practice, advocacy is central to lawyering. Practical application, students should view advocacy as a core skill. Mastery ensures client success. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.306, Social Justice and Law. Foundations of Social Justice and Law, Theories, History, and Movements. 1.1 Defining social justice, equity, equality, and rights. Social justice law seeks to address systemic inequalities and promote fairness. It distinguishes between formal equality, same treatment, and substantive equality, equitable outcomes. Rights-based approaches focus on entitlements, structural approaches focus on power dynamics. Real-life example. The civil rights movement sought substantive equality through the Civil Rights Act of 1964, addressing not just legal barriers but societal discrimination. Affirmative action policies aim to correct historical disadvantages, illustrating substantive equality. Practical application, lawyers frame arguments around equity and justice. They advocate for policy reforms. Students analyze justice theories. They also study the limits of legal remedies. 1.2 Historical movements, civil rights, labor, and feminism. Legal change often follows social movements. The labor movement achieved workplace protections. The feminist movement advanced gender equality. Civil rights movements dismantled segregation. Real-life example, Brown v. Board of Education, 1954, resulted from decades of NAACP litigation and activism. The #MeToo movement influenced sexual harassment laws. Movements shift legal landscapes. Practical application, lawyers collaborate with movements. They use litigation as advocacy. Students study movement strategies. They also analyze backlash dynamics. 1.3 Critical legal studies and intersectionality. Critical legal studies, CLS, argues law is indeterminate and reinforces power structures. Intersectionality, Crenshaw, examines overlapping identities, race, gender, class, and compounded discrimination. Real-life example, in DeGraffenreid v. General Motors, 1976, black women's claims were dismissed because they didn't fit separate race or gender categories. Intersectionality addresses this gap. CLS critiques neutral rules that hide bias. Practical application, lawyers apply intersectional analysis to cases. They challenge neutral policies with disparate impacts. Students study critical theories. They also analyze structural bias. 2. Access to justice and poverty law. 2.1 Barriers to justice, cost, complexity, and bias. Access to justice is limited by financial, procedural, and social barriers. Legal aid is underfunded. Complexity deters pro-se litigants. Bias affects outcomes. Real-life example, civil Gideon movements advocate for counsel in civil cases, housing, custody, like criminal cases. Legal aid societies serve low-income clients but face resource constraints. Court fees block access. Practical application, lawyers provide pro bono services. They simplify procedures. Students volunteer at clinics. They also study access reforms. 2.2 Poverty Law, Housing, Benefits, and Employment. Poverty law addresses needs of low-income individuals. Housing law involves eviction defense and habitability. Benefits law covers SNAP, Medicaid, TANF. Employment law involves wage theft and discrimination. Real-life example, in Goldberg v. Kelly, 1970, the court required hearings before terminating welfare benefits, establishing procedural rights for the poor. Eviction moratoria during COVID-protected tenants. Practical application, lawyers represent tenants and benefit applicants. They challenge denials. Students handle poverty law cases. They also study systemic poverty causes. 2.3 Criminal justice reform, mass incarceration and restorative justice. The criminal justice system disproportionately impacts marginalized communities. Mass incarceration results from harsh sentencing. Restorative justice focuses on repair rather than punishment. Real-life example, the First Step Act, 2018, reduced federal sentences. Bail reform movements address wealth-based detention. Restorative justice programs reduce recidivism. Practical application, lawyers advocate for sentencing reform. They represent defendants. Students study reform proposals. They also analyze racial disparities. 3. Human rights and community advocacy. 3.1 Domestic human rights, framing issues internationally. Domestic issues can be framed as human rights to leverage international norms. Housing, health, and education are human rights under international law. Real-life example, the U.S. campaign for the human right to housing frames eviction as a rights violation. This shifts policy debates. International treaties inform domestic advocacy. Practical application, lawyers use human rights frameworks in litigation. They submit shadow reports to UN bodies. Students analyze rights framing. They also study treaty implementation. 3.2 Community lawyering and empowerment. Community lawyering involves partnering with communities rather than representing them paternalistically. Empowerment builds capacity for self-advocacy. Real-life example, community land trusts empower residents to control housing. Worker centers organize laborers outside unions. Lawyers facilitate rather than lead. Practical application, lawyers engage in community education. They support grassroots organizing. Students practice community engagement. They also study empowerment models. 3.3 Impact litigation and structural reform. Impact litigation seeks systemic change through strategic cases. Structural reform injunctions reshape institutions, schools, prisons. Real-life example, Brown v. Board was impact litigation. Prison reform cases, Ruiz v. Estelle, led to systemic changes. Impact litigation requires long-term commitment. Practical application, lawyers select test cases. They manage complex decrees. Students study impact strategies. They also analyze enforcement challenges. 4. Contemporary issues and professional preparation. 4.1 Environmental justice, race, class, and pollution. Environmental justice addresses disproportionate pollution impacts on marginalized communities. Lawsuits challenge permitting and enforcement. Real-life example, in Bean v. Southwestern Waste Management, 1979, early environmental justice claims were filed under civil rights laws. EPA guidelines now consider equity. Practical application, lawyers represent communities in environmental disputes. They advocate for equitable policies. Students analyze disparity data. They also study regulatory tools. 4.2 Technology and justice, digital divide and algorithmic bias. Technology affects access and fairness. The digital divide limits online services. Algorithms in sentencing and policing exhibit bias. Real-life example, risk assessment tools in sentencing may discriminate against minorities. Online court access excludes those without internet. Justice tech must be equitable. Practical application, lawyers challenge algorithmic bias. They promote digital access. Students study tech impacts. They also analyze fairness audits. 4.3 Learning outcomes and competency benchmarks. By completing social justice and law, students should be able to analyze justice theories and movements, address access to justice barriers, advocate for poverty and human rights issues, engage in community and impact lawyering. Practical application, these outcomes are essential for public interest law and policy. Students should master advocacy for change. 4.4 Assessment methods, case studies, community projects, and policy proposals. Assessments include case studies, analyze justice issues. Community projects, partner with organizations. Policy proposals, draft reform legislation. Real-life example, a final project might involve drafting a housing justice policy. This mirrors advocacy work. Practical application, students should practice community engagement and policy analysis. 4.5 Transition to advanced courses, social justice foundations for public interest law. Social justice law underpins public interest practice. Advanced courses, civil rights litigation, poverty law clinic build on these concepts. Practice, social justice is vital for equity. Practical application, students should view law as a tool for change. Mastery ensures impactful advocacy. Slide 8. Year 3, Semester 1, International and Specialized Law. Course, Law.307, Law and Technology. Foundations of Law and Technology, Regulation, Innovation, and Rights. 1.1 The pace of law versus technology, the pacing problem. Technology evolves faster than law. This creates regulatory gaps. Law reacts to harms rather than preventing them. Adaptive regulation is needed. Real-life example, social media platforms grew before content moderation laws existed. GDPR was a reactive measure to data abuses. Self-driving cars operate in legal gray areas. Practical application, lawyers advise on compliance in uncertain regimes. They advocate for flexible regulations. Students analyze pacing challenges. They also study regulatory sandboxes. 1.2 Jurisdiction and governance in cyberspace. Cyberspace challenges territorial jurisdiction. Actors are anonymous and borderless. Governance involves states, corporations, and technical bodies. Real-life example, in Yahoo v. Lycra, 2006, French courts ordered Yahoo to block content globally, raising jurisdictional conflicts. ICANN governs domain names privately. Multi-stakeholder models emerge. Practical application, lawyers navigate cross-border tech disputes. They advise on governance compliance. Students study jurisdictional tests. They also analyze governance structures. 1.3 Intellectual property in technology, software, AI, and data. IP protects tech innovation. Software is copyrighted and patented. AI-generated works challenge authorship. Data ownership is debated. Real-life example, in Oracle vs. Google, 2021, API copyrightability was debated. AI art raises copyright questions. Trade secrets protect algorithms. Practical application, lawyers protect tech IP. They handle licensing. Students analyze IP scope. They also study open-source models. 2. Privacy, data protection, and surveillance. 2.1 Privacy frameworks, comprehensive versus sectoral. Privacy laws vary. The EU has comprehensive GDPR. The US has sectoral laws, HIPAA, COPPA. California has CCPA. Global compliance is complex. Real-life example, GDPR's extraterritorial reach affects US companies. Fines are substantial. Consent requirements are strict. Schrems 2 invalidated EU-US data transfers. Practical application, lawyers ensure global privacy compliance. They draft privacy policies. Students analyze consent mechanisms. They also study cross-border transfers. 2.2 Data breaches and security obligations. Companies must protect data. Breach notification laws require disclosure. Security standards are evolving. Liability includes fines and suits. Real-life example, Equifax breach led to massive settlements. FTC enforces security practices. Cybersecurity insurance is growing. Practical application, lawyers manage breach response. They advise on security measures. Students study notification requirements. They also analyze liability risks. 2.3 Government surveillance and civil liberties. Surveillance balances security and privacy. Warrants are required for content. Metadata has less protection. Encryption debates continue. Real-life example, in Carpenter v. United States, 2018, cell site data required warrants. Snowden revelation sparked reform debates. Backdoor mandates are contested. Practical application, lawyers challenge surveillance programs. They advise on compliance. Students analyze warrant standards. They also study encryption laws. 3. Emerging technologies, AI, blockchain, and biotech. 3.1 Artificial intelligence, liability, bias, and regulation. AI raises liability questions. Who is responsible for AI errors? Bias in algorithms discriminates. Regulation is emerging, EU AI Act. Real-life example, autonomous vehicle accidents raise liability issues. Hiring algorithms face discrimination claims. Explainability is required in some contexts. Practical application, lawyers advise on AI compliance. They handle liability claims. Students analyze liability models. They also study bias audits. 3.2 Blockchain and cryptocurrency, decentralization and regulation. Blockchain enables decentralized systems. Cryptocurrencies are regulated as securities or commodities. Smart contracts automate agreements. Real-life example, SEC enforces securities laws on ICOs. Tax treatment varies. Smart contracts face enforceability questions. Practical application, lawyers navigate crypto regulations. They draft smart contracts. Students analyze securities laws. They also study decentralization impacts. 3.3 Biotechnology and genetic engineering, ethics and law. Biotech involves genetic editing, CRISPR, cloning, and synthetic biology. Ethical concerns include consent and equity. Regulations cover safety and morality. Real-life example, He Jiankui's gene-edited babies led to criminal charges. Patenting genes is limited, myriad. Bioethics committees review research. Practical application, lawyers advise on biotech compliance. They handle IP and ethics. Students study regulatory frameworks. They also analyze ethical boundaries. 4. Contemporary issues and professional preparation. 4.1 Platform liability and content moderation. Platforms face liability for user content. Section 230 provides immunity. Reform is debated. Moderation policies affect speech. Real-life example, Section 230 shields platforms but faces criticism. EU Digital Services Act imposes duties. Moderation affects public discourse. Practical application, lawyers advise platforms on moderation. They handle content disputes. Students analyze liability shields. They also study free speech impacts. 4.2 Future of Work, Automation and Gig Economy. Technology changes work. Automation displaces jobs. Gig economy platforms classify workers as contractors. Labor laws adapt. Real-life example, Dynamex and AB5 in California reclassified gig workers. Automation raises unemployment concerns. UBI is debated. Practical application, lawyers advise on worker classification. They handle automation transitions. Students study labor impacts. They also analyze social safety nets. 4.3 Learning outcomes and competency benchmarks. By completing law and technology, students should be able to navigate privacy and data regulations. Advise on emerging tech, blockchain. Handle IP and liability issues. Address ethical and societal impacts. Practical application, these outcomes are essential for tech counsel and policy. Students should master tech law. 4.4 Assessment methods, compliance audits, policy drafting, and case analysis. Assessments include compliance audits, evaluate privacy programs. Policy drafting, write tech policies. Case analysis, brief key tech decisions. Real-life example, a final project might involve drafting an AI ethics policy. This mirrors corporate work. Practical application, students should practice tech law integration. 4.5 Transition to advanced courses, tech law foundations for IP and privacy specialization. Tech law underpins digital practice. Advanced courses, cybersecurity law, AI regulation build on these concepts. Practice, tech law is central to innovation. Practical application, students should view tech law as a future-proof skill. Mastery ensures relevance.